B group matter. No B group matters. There is an urgency in the matter. No, sir. No B group matters cannot. Fresh matters you can. 13.7 fresh matters you can give, please. Please give, sir. Let us see. Yes. Yes. Unless you mention what is the urgency, it will not come. Sumne one line urgency antara baradilla. ನೀವು ಬರ್ದಿಲ್ಲ ಅಂತಂದ್ರೆ ತಗೊಂಡು ಸರಿಯಾಗಿ ಬರ್ದ್ರೆ it will come, otherwise it won't come. You will have to write it, sir. You will have to write in the memo what is the urgency, why it has to come tomorrow itself. You have to mention, otherwise it is not going to come. Yes, I will write the urgency. ತಗೊಳ್ಳಿ ವಾಪಸ್ ತಗೊಳ್ಳಿ.
Proceeding shows that notice has not been served.
2007 na.
Produce the order sheet. Order sheet is that.
Learned AGA takes notice for all the respondents, same as 3271 of 2022. Remand alla. You have to go before the assistant commissioner. Or yenadru proceedings ಮಾಡಿ ಅದನ್ನ grant ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ that is the end of it. Otherwise they will have to consider us. There is no chance of reopening the case. Yes.
Hearing for the petition. Petitioner is challenging annexure. My lord. Order passed by the deputy commission.
Huh?
Order passed by the deputy commission. Annexure my lord. He is setting the OD carried out by the land in survey number 57, my lord. The petitioner and other villagers were
2008.
Please.
Huh?
Please.
ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು?
2016.
You are challenging it now.
Please.
We'll see. Learned AGA takes notice for response number 1 and 2. Issue notice to response number 3 and 4. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA.
Seal number 20 is also connected.
20.
Please.
Same order. Serial number 20. When was the order passed?
In the 2019.
2019.
2019.
Why didn't you?
25 to 2019.
Why didn't you approach the KAT?
There is notification that appeals are not entertainable.
2019.
Because of COVID and other reasons, the order was not communicated. It was communicated only in 2022. You were not aware of the order.
Go before the assistant commissioner.
Go before the assistant. And I have also taken the ground that it's not a speaking order. No reasons have been assigned, my lord. Will Ashit kindly see the improved order in
all right, sir. Go before the assistant commissioner. Same orders. Same order. Then a DGA takes notice for all the respondents. Same as 3271 of 2022. Yes.
Petitioner is the owner in respect of the property bearing 197/3 of Srirampura village, measuring an extent of 1 acre of the land. The respondent number 3 to 6 not have moved a suit without arraying this petitioner as a party to the proceedings, has taken a decree of declaration, and basing on the said decree, they have moved before the assistant commissioner for change of kata. The assistant commissioner, even without issuing a notice to the petitioner, passed orders inserting the name of the respondents in the with regard to the property pertaining to the petitioner. Here, my lord, there are 2 suits filed by the respondents earlier.
In your party, respondent number 1.
Anichar, I was a party. In the declaration suit, I was not made as a party.
So, what will the authority do? Can he sit over the judgment of the civil court and say, no, you party madilla, adrinda I am not going to implement the orders in Telak Barata? You will have to challenge the order of the civil court, sir. There is nothing wrong in the order.
Please, my lord, I'll take your lordship to the orders passed by the.
Sir, when once you have admitted there is a judgment and decree passed by a competent civil court, the authorities are bound to enter the names. Please see section 132.
Here is the issue, my lord. Year before.
Unless and until you challenge that judgment and decree, at least get a stay. The authorities cannot stop the persons from getting the names entered.
The catch here, my lord, before filing of the suit, my lord, there are transactions even without
so what,
my
sir?
vendors and my donors.
Please see section 132, sir.
Please.
Please see section 132 of the Land Revenue Act. There is a judgment and decree passed by a competent civil court. The authorities are bound to enter the judgment and decree and take note of the judgment and decree and enter the name.
Lord, your lordship, the decree, if at all, is against me, Lord. The authorities are bound to do it, Lord, because the responding.
They are only concerned with the survey number and the extent. Ashte.
Survey number kuda.
Authorities are not concerned, sir, whether you have been a party there or not. It is the appellate court that has to say, set aside the judgment and decree, taking note of your contention. Lord, so long as the judgment and decree is there, their names will be entered.
With liberty, will not be kindly disposed of.
Yes. Maduru in ಪ್ರಯೋಜನ ಇಲ್ಲ. Learned AGA takes notice for response number 1 and 2. Notice to response number 3 to 6 is not necessary for the following reasons. But the assistant, the grievance of the petitioner is that in terms of a judgment and decree passed in OS number 128 of 2014, dated
17/2/2020.
Where is that judgment?
It is at 109, page number 109.
Dated 17th of February 2020. Comma, the first respondent, Assistant Commissioner, Mysore Taluk, has directed in terms of the impugned order dated 15/12/2021. Cancelling MR number 17/1990-91 and directed entering the name of the contesting respondents in terms of contesting respondents in the land revenue records in terms of the judgment and decree passed by the civil court. Stop. Next para. The contention of the petitioner is that the petitioner was not a party to the proceedings in the suit in OS number 128/2004, and therefore the authority could not have directed the mutation entry in the name of the contesting respondents. Full stop. This contention cannot be accepted, since the revenue authorities are bound by a judgment and decree passed by a competent civil court, a competent court. Full stop. Unless and until the said judgment and decree is set aside or modified or stayed in accordance with law, the revenue authorities are duty bound to accept the judgment and decree passed by the court and enter the names of the parties in whose favor the judgment and decree is passed by the court. Stop. This action of the revenue authorities, this duty of the revenue authorities in taking note of a judgment and decree passed by a competent court and any appellate orders passed by the appellate court, the High Court or the Supreme Court is as contained in section 132 of the Karnataka Land Revenue Act 1964. Stop. That being the position, this court does not find any infirmity in the impugned order passed by the respondent, Assistant Commissioner, Mysore Subdivision. Full stop. Next para. Consequently, the writ petition stands dismissed. Full stop. Needless to observe that if the petitioner were to get the judgment and decree passed by the civil court reversed by the appellate court, or if an order of stay is granted against the judgment and decree, then the petitioner may approach the revenue authorities to take note of the subsequent orders and make the entries or change the revenue entries accordingly. Full stop. Ordered accordingly.
Since the petitioner was not made as a parties till then, at least some orders protecting the interest of the petitioner may kindly.
That is why I said the stay.
Please.
You at least have to go and get a stay of that judgment and decree.
Till then, at least may kindly be
no.
Some orders not to effect, implement the orders.
No, sir.
Okay.
Yes.
I have made the application regarding OD and Durasti of survey number 58 of survey village.
You have to make online application, sir.
Yes, the similar matter is already
I have it.
WP number.
So
33.
Same orders. As in WP number 551 of 2022.
Literally, subsequently, same survey number 153.
Adrite madidara.
Idrde survey number madidara. and operative portion of page 2. A mandamus issued directing the responsible court to consider the representative durability of survey number 58 of survey village, entire survey number. Not 58/21. Page 11.
None order early. I will also take note of this.
Page 11 ನಲ್ಲಿ survey number 58.
Sir, you have to file application online. As and when you file it, they will consider and pass necessary orders.
58 survey number 58, entire survey number 58. If
there is already an order, then why have you come before the court, sir?
Because separate.
I will take note of this also, but I have already passed orders and it will be according to that. And I will take note of if there is some paragraphs or statements to be added, I will add from this. Same as 551 of 2022, dated 20th of January 2022. Idunu note madkondre WP 13323 of 2022. Iduna tanpodi nanu note help. Yes. Learned AGA takes notice for where a private parties any level. Yes. So what? Sir, if you have filed a caveat, you are only going to get an opportunity to have any say in respect of the interim orders.
Interim order ಏನು ಕೇಳಿಲ್ಲ.
ಕೇಳಿಲ್ವಾ? ಮತ್ತೆ ಇನ್ನೇನು caveat?
This may be ordered in the government.
Learned AGA takes notice for response number 124.
124.
Learned Counsel Shri Anantram undertakes to file wakalat for response number 5.
Number 5.
Learned Counsel for the petitioner is directed to serve a copy of the petition on the Learned AGA and Learned Counsel for response number 5. Yes.
Sir, 79 AB, my lad. Order passed by AC, my lad. 79 AB.
Same order. Yes.
Same order.
79 AB.
79.
All right.
Rejection of the farm number 57, my lord, on the ground that, my lord, I have constructed a pig rearing shed in the land, my lord. I have constructed a shed 9 meter into 22 meter for pig rearing, my lord. I have unauthorized occupied 3 acres of land, my lord. For that, I have filed the application for regularization. For that, on the ground of pig rearing, without they have rejected the entire application itself, my lord.
What is wrong in the order?
There is no anything directly stating that Handi Sakalika Kendra Nirmesitu, Avakashavirudilla. That's the only.
Correct, sir. What is your contention?
My contention is that,
Yes.
The pig rearing is the part of the farming, my lord.
Under which provision? The point is so simple. ಅದೊಂದನ್ನು ನೀವು ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಬರ್ದಿರ, if you are not able to, I don't think you have stated anything on the legal aspects even in your grounds. What kind of pleadings are these, sir? You know what is the contention? Then why have you not referred to the legal position? Learned AGA takes notice for all the respondents. Learned Counsel for the petitioner is directed to serve a copy of the petition on the Learned AGA. Release this matter on 18th of August 2022. 108. Appeal against the orders made by the Tahsildar on the recommendations of the committee or additional committee shall lie to the assistant commissioner.
Are passed by the deputy commissioner, annexure A.
Deputy commissioner.
Yes, annexure F, my lord.
Provision illa hang baradilla. When there is a specific provision, you can't ask them to take note of the general provision. When there is a special rule regarding the appeal provision, in a case where an order is passed by the Tahsildar, considering the application filed for regularization, you can't say let them take note of the general provision. Anyway, you please point out to the provision of law, we will consider next week. Also,
Commissioner and the committee for regularization of unauthorized orders. But in the appeal, my lord, it is said that my lord, the petitioner has not submitted, my lord, the application in the appropriate format, and the application is not available in form number 53, and there is no document to show that he is cultivating it. No, Lordship, may kindly for a moment, my lord, annexure J, page 35. This case drawn by the revenue authority. Page 35. Survey number, name of the petitioner is shown, the extent is also shown. Even in form number 53, my lords, maintained by the revenue authority, page 30, my lord. Page number 30.
13.
30. Number 6. The extract, form number 53 extract, issued by the Tahsildar. There are documents available that there is a application submitted by the petitioner, and that is in unauthorized document.
Is there any elaborate order passed by the Tahsildar?
No, there is no elaborate order passed by the Tahsildar except the orders which are produced along with annexure B.
Annexure?
Annexure B. Page 15 is the order sheet. Use the type copy. Page number 24. ದಿನಾಂಕ 17/3/2001 ಶನಿವಾರದಂದು ನಡೆದ ಬಹು ಸಾಗುವಳಿ ಸಕ್ರಮ ಸಮಿತಿ ಸಭೆಯ ನಡವಳಿಕೆ. Refers to the names ನಮೂನೆ 53ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಪ್ರಕರಣಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಪ್ರಕರಣಗಳಲ್ಲಿ ಜಮೀನು ಬೇರೊಂದು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರವರ ವರದಿಯಂತೆ ಜೋಡಿ ಜಮೀನು ಆಗಿರುವುದರಿಂದ ಸಕ್ರಮಗೊಳಿಸಲು ಕಾನೂನಿನಲ್ಲಿ ಅವಕಾಶ ಇಲ್ಲದ ಕಾರಣ ಈ ಕೆಳಗಿನ ಪ್ರಕರಣ ವಜಾ ಮಾಡಲು ತೀರ್ಮಾನಿಸಿದೆ.
Then it is not a Gomad land. It is a land belonging to a Jodidar.
Now your lordship may kindly peruse the RDC page 26. 26. Annexure B. Survey number 15. Gomad. Gomad ante.
And what is the reasoning given by the Assistant Commissioner?
Assistant Commissioner says that my lord not cultivating the land. There are documents to show that my lord the petitioner is cultivating. There is a major drawn sketch prepared by the revenue authorities.
Yes. So it was earlier rejected in the year 2001.
That order, my lord, it was challenged before the Assistant Commissioner. The order which was passed in the year 2021. That was the order which was challenged before the Assistant Commissioner. Even till today, my lord, the petitioner is cultivated. There are records which indicate that, my lord, the petitioner has submitted application and that he is cultivating land. Mazar is drawn, sketch is prepared. Also, block number is also given, my lord, in the sketch.
Perfect. Learned AGA takes notice for all the respondents. Next, the petitioner who made an application in form number 53 on 30/12/1998 seeking regularization of unauthorized occupation of 2 acres of land in survey number 15, Bage village, Belagodu Hubli, Sakleshpura Taluk, Hassan district, is before this court, aggrieved by the impute orders passed by the Tahsildar, who rejected the application, and the Assistant Commissioner, who upheld the order of the Assistant Commissioner in the appeal filed by the petitioner. Next para. Learned counsel for the petitioner submits that on perusal of the orders passed by the Tahsildar, 2001 da?
ಹೌದು.
Huh?
ಹೌದು.
ನೀವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ರಾ?
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿ.
That order was passed in the year 2001.
Yes.
And you filed the appeal in 2017-18.
17.
Huh?
Yes.
ಏನು ಅದಕ್ಕೇನು ಡಿಲೇ ಅವೆಲ್ಲ ಏನು ಇಲ್ವೇ?
Delay ಅಂತಂದು it was not communicated.
Huh?
The petition.
Huh.
Therefore, my lord, as and when it was known to the petitioner, he made an appeal. He filed appeal before the appellate. Appeal is not dismissed on the ground of.
ಅದೇ ನೀವು ಏನ್ ಹೇಳೋದಿಲ್ಲ, ಅವರು ಕೇಳೋದಿಲ್ಲ. It is taken for granted. Everything is taken for granted. They also do not want to see the provisions as to whether the appeal could be entertained. You also don't state anything regarding the delay. On 17/3/2001, Annexure B, it appears that the application of the petitioner was dismissed on the ground that as per the report of the revenue inspector, the land in question does not belong to the state government, and it is a land belonging to a jodidar. Stop. On that ground, the application was rejected. Learned Counsel submits that since the order of the Tahsildar was not communicated to the petitioner, and when the petitioner came to know about the said order in the year 2017-2018, the petitioner approached the Assistant Commissioner invoking Rule 108 capital D bracket 6 of the Karnataka Land Revenue Rules, 1966, preferring an appeal on the orders passed by the Tahsildar. The Assistant Commissioner condoned the delay and considered the appeal on merits. Stop. However, it is seen from the impugned order passed by the Assistant Commissioner that as per the report submitted by the Tahsildar, it was found that the petitioner was not in occupation of the land in question, and therefore his application was rejected. Stop. Reference is made to the very same order passed by the Tahsildar on 17/3/2001. Stop. Next para. Learned Counsel for the petitioner therefore submits that it is clear from the impugned order passed by the Assistant Commissioner that no opportunity of hearing was given to the petitioner. Stop. There are contrary opinions found in the impugned orders passed by the Assistant Commissioner when compared to the order passed by the Tahsildar. Stop. Next para. On hearing the Learned Counsel for petitioner the learned AGA, and on perusing the petition papers, this court finds that although there was enormous delay on the part of the petitioner in filing the appeal for the assistant commissioner, nevertheless, the assistant commissioner has passed orders on merits while condoning the delay. However, on perusing the order dated 17/3/2001 passed by the Tahsildar while considering the application filed in form number 53, it appears that the reasons for rejecting the application is that the land does not belong to the government, and therefore there was no question of considering the application or regularization of unauthorized occupation. However, what is found in the impugned orders passed by the assistant commissioner is totally different from what is stated in the orders of the Tahsildar. According to the assistant commissioner, the application of the petitioner was rejected since it was found that the petitioner was not in occupation of the land in question. Learned counsel for the petitioner has drawn the attention of this court to the RTCs of the year 2021-22, which shows that survey number 15, which has a total extent of 14 acres 37 guntas, is said to be a Gomar land. Various extent of land have been granted for Ashraya scheme, establishment of government offices, for the Road Transport Corporation, for establishment of residential houses, etc. Therefore, the opinion of the Tahsildar in terms of the order dated 17/3/2001, that the land in question is not Gomar land and cannot be granted, requires reconsideration. Similarly, learned counsel for the petitioner has also drawn the attention of this court to Annexure F, which shows that the factum of the petitioner making his application in the year 1998 was found in the register maintained by the Tahsildar, Sakleshpura Taluk. At Annexure J, which is a measure drawn by the Taluka surveyor, it is found that the petitioner is in unauthorized occupation of 2 acres of land in survey number 15 of ಯಾವ village ಅದು? Bage village zones. Stop. Thus, there being contrary opinions of the Tahsildar and the Assistant Commissioner, comma, the impugned orders cannot be sustained. Stop. It is also evident that no opportunity of hearing was given to the petitioner to have his say if there was any objections on the part of the authorities. Stop. On both these counts, the impugned orders are required to be set aside. Next para. Consequently, the writ petition is allowed. The impugned orders dated 17/3/2001 passed by the respondent Tahsildar and the appellate order in NCR number 324/2017-18 dated 30/10/2018 passed by the Assistant Commissioner, Sakleshpura Subdivision are hereby quashed and set aside. Full stop. The matter stands remitted back to the Tahsildar, Sakleshpura Taluk to place the application of the petitioner before the Committee for Regularization of Unauthorized Occupation. Stop. The committee shall give an opportunity of hearing to the petitioner to substantiate his contention that he is in unauthorized occupation of the land in question. Stop. The committee shall hear the petitioner, cause an inquiry, and thereafter pass necessary orders in accordance with law as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order. Stop. Ordered accordingly.
Not evict the
Till there is consideration of the application filed by the petitioner at the hands of the committee, no precipitative action shall be taken against the petitioner for evicting him from the land in question.
Therefore, the petitioner is not because the petitioners are therefore this honorable court for seeking for the intervention of the honorable court pursuing of mandamus to consider the representations of the petitioner filed before respondent number 2 and 3, my lords. My lords, so the case of the petitioner, the background of the case is such that the petitioner previously came before this honorable court pertaining to the land in question at survey number 5, block numbers 26, measuring 3 acres. They filed the petition to the honorable court with a prayer for mandamus. Since the representation was not considered for Durast and Podi, the same came to be disposed of and to be complied within 6 months. The said order was not complied, and hence a contempt proceeding was initiated. At that point of time, my lords, the Tahsildar has produced a letter at Annexure D, my lord, which is at page number 22, stating that the Durast has been done. Survey number 5 has been changed to new survey number 50. Annexure D, my lord, page 22. Subsequently, my lord,
this was a communication made by the Tahsildar to the Assistant Commissioner. Annexure D.
My lords, this was produced at before this honorable court during the contempt proceeding.
Correct. It was a communication dated 25/2/2022 made by the Tahsildar to the Assistant Commissioner.
Please, my lord.
Yes.
Subsequently, my lord, the contempt proceeding was dropped owing to the said letter. This being the case, my lord, on 34/2022, 2022 at Annexure F, my lord, the petitioner has produced his RTC, my lord. Said survey, I mean, as per Duras that has been done, survey number 50 ought to have been shown. However, survey number 5 is still depicted in said RTC, my lord, at Annexure F, page 75.
That is the only grievance.
That is the only grievance, my lord. Mutation has not been done, and owing to which there is a representation that has been done.
Please see Annexure D. ಅದರಲ್ಲಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಎರಡನೇ ಲೈನಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕೃಷ್ಣರಾಜಪೇಟೆ ತಾಲೂಕು ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಕಾರಿಗಾನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 5 ಬ್ಲಾಕ್ ನಂಬರ್ 26ರಲ್ಲಿ 3 ಎಕರೆ ಮಂಜೂರಿಯಾಗಿದ್ದು, ಈ ಜಮೀನನ್ನು ದುರಸ್ತಿಯಂತೆ ಹೊಸ ನಂಬರ್ 50 ಎಂದು ಆಗಿದ್ದು ಅವರೇ ಹೇಳ್ತಾರೆ. ವೈ ದೆನ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಶೋನ್ ದಿ ನ್ಯೂ ನಂಬರ್. Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. Next para. The grievance of the petitioner is that in terms of the communication dated 25/2/2022 at Annexure D made by the Tahsildar, KR Pete to the Assistant Commissioner, Pandavpura Subdivision, wherein it was stated that old survey number 5, block number 26, measuring 3 acres, have been assigned new number 50, and orders of the Assistant Commissioner are required to conduct the Kodi and Durast in view of the orders passed by this court in WP number 6383 of 2021, dated 30th of March 2021, and the pendency of the content proceedings in CCC number 97 of 2022. And taking note of the said communication, the content proceedings were dropped. Stop. However, in the RTC, old survey number 5 is continued, and therefore the petitioner has given a representation to the respondent authorities to show new survey number 50 as indicated in the communication dated 25/2/2022. Full stop. Next para. Learned HCGP is directed to secure instructions as to why the new survey number is not shown in the RTC. Full stop. Next para. Release this matter on 18th of August 2022.
The land in Malada, the baby betta, is the absolute property of the then Maharaja of Mysore. Malad, the Kata, Malada have made representation for changing the Kata, but since it has not been Malada seeking a direction to effect the Kata, but this property has been acquired by the Maharaja under the treaty with the then government of India and the Maharaja of Mysore. Page 22, Malad. In respect of the properties in the list of properties at page 22. Baby betta. Page 32.
What is the document?
This is the list of properties which is submitted by the then Maharaja of Mysore before the government of India. And as per the agreement, Malad, these properties are treated as the private property of the then Maharaja of Mysore. 1620.7 guntas, Malad, baby betta is the absolute property of the then Maharaja of Mysore. Even at there Annexure A, Malad, in column 9, Malad, it has been mentioned as Mysore Samsthanada Maharajaravara Amrut Mahal Kavalu. Page 16 in RTC. column 9.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition on the learned AGA. The respondent state, along with the deputy commissioner, are required to file statement of objections in this matter within a period of 2 weeks from today. Yes.
My lord, I am for the petition.
Yes.
My lord, in this matter, the petitioner's grandfather had purchased this 5 acres land in survey number 4, which was granted. Yes, sir, yes, Podi. And
you will have to make online application.
No, my lord, I draw your lordship's to annexure A.
Sir, you are required to make online application. You please make online application. It will be considered within a stipulated time. These are the orders I have passed. Same orders will be passed.
I my lord. Annexure A, Joint Director of Land Records had passed the order, my lord, to survey.
All right, sir.
Yes.
See, the position now is that you are required to make application online with all the relevant documents. If you make that, we will direct them to consider within the stipulated time. Please do it. Same as 551 of 2022, dated 20th of January 2022. Learned AGA takes notice for all the respondents.
Seek for a pass out.
79. Pass over.
My colleague was here filing with him.
Pass over. These are all matters that are covered.
No notice was issued in this case.
Howdo?
Case was registered in the name of my husband.
Go before the assistant commissioner. He will consider and pass order. Same as 3271 of 2022. Then at AGA, HCGP takes notice for all the respondents. Yes.
Petitioner has been in occupation of unauthorized cultivation. He has filed an application for regulation of unauthorized cultivation, and it is pending before the second respondent. A direction, I'm seeking a direction.
93, 94.
Yes.
Learned AGA takes notice for both the respondents. Next para. The prayer in the writ petition is to issue a writ of mandamus directing the respondents to consider the application filed by the petitioner in the year 1993, seeking regularization of unauthorized occupation of 3 acres and 29 guntas of land in survey number 322 of Kamsenahalli, Kodigehalli, Hobli, Madhugiri Taluk, Tumkur district. Stop. Next para. It is the contention of the petitioner that he filed application in form number 53 way back in the year 1993, and till date no orders are passed on the application filed by the petitioner. Stop. Next para. Having regard to the contention of the petitioner and the prayer made in the writ petition, this court is of the considered opinion that the Tahsildar, Madhugiri Taluk, is required to ensure that the application filed by the petitioner is placed before the committee for regularization of unauthorized occupation. So, if no such application is found, then the Tahsildar is required to issue an endorsement to the petitioner. Stop. However, if it is true that the application filed by the petitioner is found in the records, then the Tahsildar shall immediately place the same before the committee, and the committee shall consider the application by affording an opportunity of hearing to the petitioner, cause inspection, and thereafter pass orders in accordance with law as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order. Stop. Ordered accordingly.
Yes, my lord, land by annexure B, my lord, in the year of 1956. Thereafter, my lord, the name of the petitioner has been shown, my lord, in the RTC. Thereafter, continued, my lord. He continued. Thereafter, my lord, the respond number, my lord, 3 has filed, my lord, the application under form number 7. My lord, sought for the occupancy rate by showing, my lord, some others' name, my lord, in the form number 7. Page number 43 ಅಲ್ಲಿ ಗೋಪಾಲ್ ಆಚಾರ್ಯ ಅಂತ ತೋರಿಸ್ತಾರೆ. petitioner ಅವರ ಫಾದರ್ ಹೆಸರು ಧೂಮ ಮಡಿವಾಳ. Page number 38, my lord, I have produced the RTC from the year 68 to, my lord, 79. Column number 9, my lord, the owner's name. Petitioner's father's name is, my lord, shown even in the year 1968, my lord. And, my lord, without showing the original owner's name, my lord, they have shown, my lord, one Gopal Acharya. And, my lord, the tribunal has granted, my lord, the lands, my lord, in favor of, my lord, respond number 3 at annexure A, my lord. Even now, my lord, we are in the position, my lord, even today, my lord, there are, my lord, agricultural crops are present, and, my lord, is in the possession of the petitioner. Now we came to know that, my lord, they are coming, my lord, to dispose the land. When, my lord, we have inquired, my lord, this order came to be passed by, my lord, showing some others' name, my lord, delay of 40 years. Even now, my lord, we are in the position. We are now trying to, my lord, dispose this, my lord, by virtue of this order. That's why, my lord, we have applied for, my lord, certified copies. My lord, I have produced the original, my lord, the Mulageni Krayapatra at annexure B, my lord. It is the property which is purchased by the father of the petitioner, Mr. Duma Madiwala. His name is, my lord, even today, my lord, it is shown, my lord, in the RTC. I have produced the, my lord, RTC also. 45 only. 9/3B. Duma Madiwala Kambali Bettu Tukur. 82 ತನಕ ಇದೆ.
Survey number 9-3B.
3B. Page number 15 order ಅಲ್ಲಿ 9/3B. 3 ಗುಂಟೆ ನಂಚ. Other survey numbers are concerned, my lord. The petitioner has no objection.
In the sale deed.
ಹೌದು.
What is survey number shown? That what have you purchased?
Page number 23 ಅಲ್ಲಿ ಇದೆ. ಅದರಲ್ಲಿ 8/1, 8/3, 9/2, 9/6A, 9/6B, 9/7, 9/3B. ಅಜ್ಜ 3 ಸೆಂಟ್. 9/6A ಮತ್ತು 9/3B only ಎರಡು schedule ಮಾತ್ರ dispute ಅಲ್ಲಿ ಇರುವಂತ. Remaining survey numbers are concerned, my lord, I have no objection. That is in their possession.
9-3B.
3B ಮತ್ತು 6A, my lord. ಎರಡನೇ schedule 9/2 ನ ನಂತರ ಇದೆ 6A ಮತ್ತು 3B. 6A RTC ಕೂಡ 1968 ಇಂದ ನನ್ನ ಹೆಸರೇ ತೋರಿಸ್ತಾರೆ, ಫಾದರ್ಸ್ ಹೆಸರೇ ತೋರಿಸ್ತಾರೆ. Not produced.
Also, my lord, the tribunal also, my lord, while granting, my lord, has not considered, my lord, the RTCs and issued notice to the original owner. There is a threat of dispossession, my lord. Better not dispossess, my lord. Let them file their objection, my lord. The ex parte order ಆಗಿದೆ. Annexure A ಅಲ್ಲಿ page number 14 ಅಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿಕೊಂಡು ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಸೆಕ್ಷನ್ 48 ಪ್ರಕಾರ ಈ ಕೆಳಗಿನ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಸೂಚಿಸುವ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿಗೆ ಅನುಭೋಗದಾರರೆಂದು ನೋಂದಾಯಿಸಲು ಸರ್ವಾನುಮತಕ್ಕೆ ಏಕಪಕ್ಷೀಯವಾಗಿ ಘೋಷಿಸಲಾಯಿತು. Has been shown as my lord the owner. He has also my lord not appeared.
Learned AGA takes notice for response. HCGP takes notice for response number 1 and 2. Issue notice to response number 3 and 4. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned HCG. Full stop. Next para. The grievance of the petitioner is that on the strength of an order passed by the first respondent land tribunal, Mangalore on 24/6/1981 at annexure A, the contesting respondents number 3 and 4 are seeking to dispossess the petitioner in the lands and
in respect of survey number 9/3B1 and my lord 9/6.
full stop.
6/1.
It is the contention of the petitioner that the petitioner's father, late Sri Duma Madiwala, purchased several extents of land under a registered sale deed dated 2/3/1956 at annexure B, including the lands in survey number 9/3B, measuring
3 cents.
huh?
3 cents.
3
0.3 cents. Mangalore cents.
3 acres 24 cents ಅಂತಾರಲ್ರಿ, ನೀವು 3 ಗುಂಟಾಸ್ ಅಂತ ಇದ್ದೀರಾ. Please see page number 23.
Page number 15.
Page number 23 original sale deed ಅಲ್ಲಿ ನೋಡ್ರಿ, 9B 3-24 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಅವ್ರ ಕ್ಲೇಮ್ ಹೌದು, ನಾವು ತಗೊಂಡಿದ್ದು 3 acres. ಅವ್ರದ್ದು ಕ್ಲೇಮ್ 3 ಗುಂಟೆಗೆ 3 ಸೆಂಟ್ಸ್ಗೆ ಮಾತ್ರ.
ಇನ್ಕ್ಲೂಡಿಂಗ್ ಏನಂದ್ರೆ 3 acres 24 cents and 9/6A measuring 48 cents. Stop. It is contended that the petitioner nor his father, late Sri Duma Madiwala, is a party to the proceedings conducted by the land tribunal.
Not a party.
They not a party. Stop. The order passed by the land tribunal is not applicable or executable against the petitioner. Stop. Next para. Consequently, the respondent authorities and response number 3 and 4 are directed not to precipitate the matter till the next date appearing. Yes, please.
Here, you take my lord, take my submission. My lord, within 2 days, the deputy commissioner passed the orders, my lord, without giving opportunity. Within 2 days.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ACR na set aside.
Huh?
ACR. Set aside.
What was the AC order?
AC order directed entry my
You
name.
approached the assistant commissioner.
Yes, my lord. I approached the.
Where is that order?
Yes, my lord. Annexure, yes, my lord.
2016-17.
Yes, my lord.
Huh?
Yes, my lord.
Appeal under what provision?
136 2, my lord.
Challenging what?
Challenging MR, my lord.
MR number?
9596. MR number 55 9596.
95-96.
Yes, my lord.
How could he entertain that appeal at the belated stage?
My lord, they contested the matter, my lord, because I'm a bona fide purchaser. I purchased the property. My husband purchased the property in the year 1972. 1972 to 1995, without my name has been continued. My husband name.
It was continued.
Yes, my lord.
95-96,
without my knowledge, the fourth responding name came to the end. So I came to know 2017 and 18.
Then it appears you were never went to the land. You did nothing.
No, my lord. I'm cultivating the land.
I'm
a bona fide purchaser.
If you were cultivating, then the dispute would have raised immediately thereafter.
My lord, what he has purchased the property, he has no right, my lord. He is a fictitious person. I purchased the property in 1990.
He is also purchased the property.
Purchased the property in the year 1996. My lord, because he has no right to sold the property.
That the civil court has to decide.
They filed a civil suit and they withdraw the suit. In view of entering the name, my lord, they filed a memo. They withdraw the suit before deputy commissioner, my lord.
No, sir. You have to go. You have to go before the.
Just one appearance I filed Okolat. After that, immediately pass the orders. Give me opportunity before deputy commissioner.
Sir, that is what is going to happen even before this court. This first hearing itself, I can dispose of the matter. There is nothing in this. Go before the civil court. Establish your title. Get the records changed. After a lapse of more than 15-16 years, you can't approach the assistant commissioner seeking change of the mutation entries. Madak barala.
My lord, originally the
because
yes,
right or wrong, his name has been entered consequent to a registered instrument, and law says it has to be entered.
My lord, my title, my lord. I purchased the property. I never sold the property.
Therefore, that is why, sir,
yes, my lord.
This court has time and again held. It is not the revenue authorities that can sit over the matter and consider the title. It is only the civil court.
My lord,
go before the civil court.
My lord, 95 up to 95 without issuing a notice.
Correct, sir.
Without issuing a notice to
correct.
They have changed the mutation.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. For 15-16 years, if you have remained without questioning it, we cannot do anything.
ನನಗೆ ನೋಟಿಸೇ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕೆಂದ್ರೆ ಅವರು ರೆಕಾರ್ಡ್ಸ್ ಚೇಂಜ್ ಮಾಡ್ಕೋಬೇಕಾದ್ರೆ.
Sir, there are so many things involved in this.
Value of
The very fact that you remained silent for 15-16 years without questioning it shows that you have never gone towards the land.
My lord, I'm in a position of the property.
So all these things have to be considered by the civil court.
My lord, in your entering in the name of the respondent, so disturb my position.
Huh?
Disturbing my position.
We are not going into all these questions, sir. We are only concerned with the revenue entries. You approach the assistant commissioner.
Yes, ma'am.
Seeking change in the revenue entry.
Yes, ma'am.
He has passed an order.
Yes.
That has been set aside by the deputy commissioner.
Without
We are only concerned with the revenue entries.
My lord, without giving me opportunity, deputy
Correct, sir.
I am going to LCA to establish my rights.
Our bunde marak baralla, sir. Neither can you do it before this court.
Thank you.
You will have to go before the civil court. Which was that original suit that you had filed?
They have withdrawn, my lord. It is as per annexure. I withdrawn my lord. 62, man. R62. I filed a misdemeanor. Case number 139.
Perfect.
Facts of the case, my lord.
Notice has been ordered.
I have. I am the contesting party. For this.
The petitioners.
My lord, if the fraud has taken place by entering the revenue entries, the deputy commissioner.
Fraud ಹೆಂಗೆ ಸರ್ ಆಗುತ್ತೆ? Registered instrument ಇದೆ ಸರ್. Please see section 128.
Yes, my lord. But registered instrument who has executed.
All that has to be decided by the civil court, sir. The revenue authorities cannot decide all this.
Thank you.
In terms of section 128, if there is a registered instrument, the name of the purchaser has to be entered in the land revenue record.
The assistant commissioner goes to the extent of saying that my documents.
It may be true that you have not sold the property and your name was standing in the records earlier. But the provision says that if the person has acquired title under a registered instrument, the revenue authorities are bound to enter the name. So it is for you to question that one before the civil court. The authorities cannot decide this issue, sir.
State Commissioner says that my registered documents are null and void. He has no jurisdiction.
All right. The petitioners are aggrieved by the impugned order dated 25/10/2021 in revision petition number 61 of 2021 dated 25th of October 2021. Stop. Next para. The petitioners approached the assistant commissioner raising an appeal under section 136 bracket 2 in dispute bearing RA bracket H clause 65 of 2016-17 challenging mutation entries made in the name of the contesting respondents in MR number
52/95/96.
52/95/96. Stop. The assistant commissioner proceeded to hold that though the contesting respondents acquired title over the land in question under a registered sale deed dated 1/2/1978. Huh?
No, my lord, 14/2/1996.
14/2/1996.
Yes, ma'am. And what both, ma'am. 2/1978 and 14
Ah.
to 78.
ಅದು ನಿಮ್ದಾ?
ಅಲ್ಲ ಅವ್ರು ಇಲ್ಲ, ನಮ್ದು 72.
ಆಲ್ ರೈಟ್.
ಅವರಿಗೆ ಮಾರ್ದವ್ರಿಗೆ ರೈಟ್ಸ್ ಇಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ. Registered instruments dated 1/2/1978, followed by another registered instrument dated 14/2/1996.
Yes. 1/2/1978 gifted, my lord.
Nevertheless, since earlier the Khata stood in the name of the petitioner's herein in terms of a registered sale deed dated
9/6/1972.
9/6/1972, and the then Khatedar yaro
Muni Chennegowda, my
Sri Muni Chennegowda had not executed the sale deed dated 1/2/1978.
not 1/2, my lord, 14/2/96. 1/2/1978 gift deed executed in favor of Muni Venkatama, the daughter of one Muniyamma.
Or the sale deed dated 14/2/1996, the assistant commissioner proceeded to hold that no title passed on to the contesting respondents herein. So consequently, the appeal was allowed and the mutation entries in terms of MR number 52 of 1995-96 was directed to be cancelled, and the name of the petitioners were directed to be entered in the land revenue records. Full stop. The contesting respondents approached the deputy commissioner by filing a revision petition in revision petition number 61 of 2021, and the deputy commissioner proceeded to pass the impugned order. So, next para. Learned counsel for the petitioner submits that the impugned order has been passed without hearing the petitioners, and on that ground alone, the impugned order is required to be set aside. Stop. Next para. Per contra, it is the contention of the learned counsel for the contesting respondents that the assistant commissioner could not have entertained the appeal filed after a belated period of nearly 15 to 16 years after the mutation entries were made in the land revenue records. Stop. Moreover, it is not for the revenue authorities to sit over the title, not for the revenue authorities to decide the title of the parties. Therefore, the deputy commissioner has rightly held that the aggrieved persons have to approach the competent civil court and get a declaration at the hands of the civil court. Stop. Next para. Having heard the learned counsel for the petitioners, the learned counsel for the contesting respondents, the learned AGA, and on perusing the petition papers, this court finds that although it is contended by the petitioners that they were not heard by the deputy commissioner before passing the impugned order, nevertheless, the decision of the deputy commissioner is in accordance with law. Stop. The learned counsel for the contesting respondents is right in his submission that the petitioners could not have approached the assistant commissioner invoking section 136 bracket 2 of the Karnataka Land Revenue Act in the year 1996-97, questioning a mutation entry made in the year 1995-96. So, a belated period of 20 years.
3 years. 20 years.
20 years agutte, sir. 95-96.
2000.
Proceeds to the Karnataka Land Revenue Act in the year 1976, the mutation into made in the year 95-96.
In MR number 52/1995-96. Stop. Time and again, this court has held that the revenue authorities cannot decide the title of the parties. Stop. If it is the contention of the petitioners that no right, title, or interest passed to the contesting respondents under the gift deed dated 1/2/1978 or the sale deed dated 14/2/1996, nevertheless, these questions are required to be considered by a competent civil court in a duly constituted suit filed at the hands of the aggrieved persons. Stop. It is the civil court alone which can declare the title of the parties.
Declaration
Stop.
suit is dismissed, my lord. They have withdrawn the suit. On 31
It was also brought to the notice of this court that in fact the petitioners had filed OS number
431 of 2012. The file of the 5th additional senior civil judge
seeking
declaration and injunction.
declaration of their title.
Yes.
However, the said suit was withdrawn
Withdrawn by
On?
filing a memo on 31/7/2021
And filed a miscellaneous petition.
for restoration. You are not aware of.
Stop.
You are not aware.
Then a counsel for the petitioners submits that the petitioners have filed a miscellaneous petition seeking to recall
Yes.
the order of withdrawal.
Yes.
Full stop. Nevertheless, as noticed here in above, if the petitioners seek to have their names entered in the land revenue records, it shall be done only after a declaration is made by the competent civil court declaring the right, title, and interest of the petitioners in the land in question. Full stop. So long as such an order, such a judgment in decree is not obtained by the petitioners, they shall not be permitted to approach the revenue authorities to have their names entered in the land revenue records. So, next paragraph. Consequently, the petition stands dismissed.
In view of revenue interest, they're going to create a third party interest. They should not. In fact,
ಅದನ್ನು ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ನೀವು will have to take a interim order. Full stop. Ordered accordingly.
Should withdraw ಮಾಡಿದ್ಮೇಲೆ they have entered into the listed agreement of sale to sell the lands and possession to third party.
ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ.
They have not received
Go
legal
before the
notice
civil court. Yes.
Thank you.
Madam, my lord, I have challenged the endorsement which has been issued on 17/20/2020, my lord, which has second responder. Earlier, I had filed this petition, my lord, and the direction was made by this honorable court to consider the representation for Darkhast and board and pass necessary orders to that effect, my lord, on 17/1/2022, and what was passed to that effect. I also again given fresh representation.
You are required to make an application online.
Yes,
Madidra?
Because since the online application was not taken in the computer, my lord, again we gave a representation. Twice we have given a representation on 14/2 and 22/2. Based on the said representation, the second respondent has passed an order that since the no records are available with regard to grant of the land, and hence the claim which has been made by the petitioner cannot be granted. Because
If you are not able to establish how you got rights over the property, what will they do?
I am having right over the property, my lord. Their condition, they have handles election grant agide anta avare records alli heltare. I am the subsequent purchaser from that, my lord. In the annexure D, my lord, it is at page number 19. ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಪ್ರಕಾರ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಕೋಡಿ ಮತ್ತು ದುರಸ್ತಿಗಾಗಿ ಆನ್ಲೈನ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದ್ದು, ಅದರಂತೆ ಆನ್ಲೈನ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಮೂಲ ಮಂಜೂರಾತಿ ದಾಖಲೆಗಳ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಈ ಕಚೇರಿ ಅಭಿಲೇಖಾಲಯದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಯಾವುದೇ ಮಂಜೂರಾತಿ ಕಡತ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಆದಾಗ್ಯೂ ಅಭಿಲೇಖಾಲಯದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಕಂದಾಯ ದಾಖಲಾತಿಗಳು RR ನಂಬರ್ 6/1967-68 ರಿಂದ 99/2000 ಕೈಬರಹ ಪಹಣಿಗಳು ಹಾಗೂ ಮ್ಯೂಟೇಶನ್ ದಾಖಲಾತಿಗಳು ಕುಲಕುಶವಾಗಿ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿತ್ತು. RR 6 ಪ್ರಕಾರ ಅಂದರೆ ಇಂಡೆಕ್ಸ್ ಆಫ್ ಪ್ಲಾನ್ಸ್ ಪ್ರಕಾರ ಚೀಲನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 16ರಲ್ಲಿ ಒಟ್ಟು 31 ಎಕರೆ 25 ಗುಂಟೆ ಜಮೀನಿದ್ದು ಸರ್ಕಾರಿ ಎಂದು ನಮೂದು ಆಗಿರುತ್ತದೆ. ಒಂದು ವೇಳೆ ಯಾವುದೇ ವ್ಯಕ್ತಿಗೆ ಜಮೀನು ಮಂಜೂರಾಗಿದ್ದಲ್ಲಿ ಸದರಿ ಇಂಡೆಕ್ಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸಮೇತ ನಮೂದು ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. 1967-68 ರಿಂದ 76-77 ಸಾಲಿನ ಕೈಬರಹ ಪಹಣಿಯಲ್ಲಿ ಸರ್ಕಾರಿ ಪಡ ಎಂದು ನಮೂದು ಆಗಿರುತ್ತದೆ. ಆದರೆ 1977-78 ಸಾಲಿನಿಂದ 96-97 ಸಾಲಿನವರೆಗೆ ಪಹಣಿಯಲ್ಲಿ GR ನಂಬರ್ 671-59-60 ಪ್ರಕಾರ ಪುಟ್ಟನಾಯಕ ಬಿನ್ ಸಣ್ಣ ಓಬನಾಯಕರ್ ಅವರಿಗೆ 10 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುತ್ತದೆ ಎಂದು ಪಹಣಿ ಕಲಂ 9ರಲ್ಲಿ ನಮೂದು ಆಗಿರುತ್ತದೆ. ಇಟ್ ಈಸ್ ಮೆನ್ಷನ್. ಅದೇ ರೀತಿ 1982-83 ರಿಂದ 86-87 ಸಾಲಿನಲ್ಲಿ ಕೈಬರಹ ಪಹಣಿಯಲ್ಲಿ ಕಲಂ 9 ಮತ್ತು 10ರಲ್ಲಿ ಪುಟ್ಟನಾಯಕ ಬಿನ್ ಸಣ್ಣ ಓಬನಾಯಕರ್ ಅವರಿಗೆ GR ನಂಬರ್ 671/59-60 ದರಖಾಸ್ತು ಎಂದು ರಾಮದಾಸ್ ಬಿನ್ ಪುಟ್ಟನಾಯಕರ್ ಅವರಿಗೆ ICR ನಂಬರ್ 2/86-87 ದಿನಾಂಕ 26/8/86 ಬಂದಿರುತ್ತದೆ ಎಂದು ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. 1987-88 ರಿಂದ 91-92 ಕೈಬರಹ ಪಹಣಿಗಳಲ್ಲಿ ಕಾಲಂ 9ರಲ್ಲಿ ರಾಮದಾಸ್ ಬಿನ್ ಪುಟ್ಟನಾಯಕ ಪವತಿ ವಾರಸು ಮೇರೆಗೆ ICR ನಂಬರ್ 22/86-87 ದಿನಾಂಕ 26/8/86 HD ರಾಮನಾಯಕ ಬಿನ್ ದೊಡ್ಲಿಂಗನಾಯಕರವರಿಗೆ MR ನಂಬರ್ 1/88 ರಿಂದ 26/10/86 ಖಾತೆಯಾಗಿರುತ್ತದೆ ಎಂದು ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಮೂಲ ಮ್ಯೂಟೇಶನ್ ವಹಿಗಳಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ 1967-68 ರಿಂದ ಪ್ರಾರಂಭಗೊಂಡಿರುವ ಮ್ಯೂಟೇಶನ್ ವಹಿಯಲ್ಲಿ 88-89 ಸಾಲಿನ ಅಂತ್ಯಗೊಂಡಿದ್ದು, ಸದರಿ ವಹಿಯಲ್ಲಿ MR ನಂಬರ್ 1/8889 ಎಂದು ದಾಖಲಾಗಿದ್ದು, ರಾಮದಾಸ್ ಬಿನ್ ಪುಟ್ಟನಾಯಕರವರಿಂದ ಹಿರಿಯೂರು ಟೌನ್ ವಾಸಿಯಾದ HD ರಾಮನಾಯಕ್ ಬಿನ್ ದೊಡ್ಡಲಿಂಗನಾಯಕ್ ಅವರಿಗೆ ದಿನಾಂಕ 19/6/87 ನೋಂದಣಿ ಕ್ರಯವಾಗಿದ್ದು, ಕ್ರಯದಾರರ ಹೆಸರಿಗೆ ದಿನಾಂಕ 27/5/88 ಮ್ಯೂಟೇಶನ್ ಅಂಗೀಕರಿಸಲ್ಪಟ್ಟಿರುತ್ತದೆ. ಅದೇ ಸಾಲಿನಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಲಕ್ಷ್ಮೀಸಾಗರ ವೃತ್ತದ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿ 1988-99 ಸಾಲಿನ ಮತ್ತೊಂದು ಮ್ಯೂಟೇಶನ್ ವಹಿಯಲ್ಲಿ ತೆರೆದಿದ್ದು, ಸದರಿ ವಹಿಯಲ್ಲಿ ಪುನಃ MR ನಂಬರ್ 1/8889 ಎಂದು ಮ್ಯೂಟೇಶನ್ ಸಂಖ್ಯೆ ನಮೂದಿಸಿ ರಾಮನಾಯಕ ಬಿನ್ ದೊಡ್ಲಿಂಗನಾಯಕ ಅವರಿಂದ ಪ್ರಶ್ನಿತ ಜಮೀನು ದಿನಾಂಕ 6/8/88 ಶ್ರೀ G ರಂಗಯ್ಯ ಬಿನ್ ರಂಗಣ್ಣನವರ ನೋಂದಣಿ ಕ್ರಯಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿದ್ದು, ದಿನಾಂಕ 26/10/88 ಕಸಬಾ ಹೋಬಳಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಮ್ಯೂಟೇಶನ್ ಅಂಗೀಕರಿಸಿರುತ್ತಾರೆ. This is the mutation which has been entered in the name of my husband. After his death, the name of the petitioner has been entered. ಈ ಎಲ್ಲ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಕೆಳಕಂಡ ಆಧಾರದ ಮೇರೆಗೆ ಪ್ರಶ್ನಿತ ಜಮೀನು ಮೂಲ ಮಂಜೂರಾತಿ ದಾಖಲಾತಿ ಇರುವುದಿಲ್ಲ ಎಂದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಜಿಆರ್ ನಂಬರ್ 671/5960 ದರಖಾಸ್ತು ಮುಖಾಂತರ ಪುಟ್ಟನಾಯಕ ಬಿನ್ ಸಣ್ಣ ಉಪನಾಯಕರವರಿಗೆ ಮಂಜೂರಾತಾಗಿರುತ್ತದೆ.
Learned AGA takes notice for both the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. The petitioner herein had earlier approached this court in WP number 332 or 2022, and this court, by order dated 27th of January 2022, had directed the petitioner to file an online application for OD and Durast work, and as and when such application is filed, the respondent authorities were directed to consider the application and carry out the OD and Durast work in accordance with law within a period of 2 months from the date of receipt of the application. Full stop. However, learned counsel for the petitioner contends that the Tahsildar, respondent Tahsildar, Sira Taluk, has issued the impugned endorsement dated 17/3/2022, declining to conduct the OD and Durast work on the ground that the petitioner has failed to produce the original documents regarding the grant of land said to have been made in the year 1967-68. Stop. On going through the impugned order, this court finds that there have been mutation entries in the land revenue records in respect of the original grant, and thereafter the sale made by the original grantee. 67-68 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, 59-60 ಅಂತ ಹಾಕಿ. Original grantee Shri Puttanaika. Thereafter, Sri Ramadas, son of Puttanaika, son of Puttanaika's name was also entered in the land revenue records in ICR number 2/8687. Stop. Sri Ramadas has later sold the property in favor of Sri H.D. Ramanaik, son of Doddalinga Naik, under a registered sale deed dated 19/6/1987, and the name of the subsequent purchaser Sri H.D. Ramanaik was entered in the land revenue records. ನಿಮ್ಗೆ ಹೆಂಗಮ್ಮ ಬಂತು?
26/10/1988.
Thereafter, the petitioner's husband, Sri G. Rangayya, purchased the land in question, measuring 10 acres.
10 acres. 6/8/1988.
Under a sale deed dated 6/8/1988.
Yes.
And the name of Sri Rangayya was also entered in the land revenue records. Good stop. Next para. This court has time and again held that the Tahsildar cannot call for the original records to carry out the mutation entries or to conduct OD or Durast work after maintaining the land revenue records for several decades, and the party approaches the Tahsildar for conducting Podi and Durast work consequent to registered instruments. Full stop. Para. Release this matter on 18th of August 2022. Stop. The respondent Tahsildar Sira Taluk shall be kept present before this court on the next date of hearing. A copy of this order shall be served on the learned AGA for compliance. Yes.
Annexure A is the TT, my lord, paid in the TT fine. Next page number 17. Favorable copy, my lord, page number 18.
You know?
TT fine. Page number 18 ಅಲ್ಲಿ TT fine ಕಟ್ಟಿದ್ದಾರೆ 493 ರೂಪಾಯಿ. Then my form 50 annexure B, my lord, in respect survey number 210, measuring 3 acres. Annexure B, form 50. When 1620, right? Then my annexure C is sketch work prepared by the authority on 1984. Then my land, the sketch annexure D is the Mahazar. Annexure D is the inspector, Tahsildar Mahazar, my land, annexure ಈ page number 29. ಇನ್ನೊಂದರಲ್ಲಿ 220 ಜಮೀನನ್ನು ಹಾಜರು ಮಾಡ್ತದೆ. ಇಸ್ ಪೊಸಿಷನ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಶಾಂತಿ ಗ್ರಾಮದ ಕೆ ಬ್ಯಾಡಲ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 210ರಲ್ಲಿ 220 ಗುಂಟೆ ಜಮೀನು ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ವರದಿ ನೀಡಲು ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತದೆ. ದ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಡೈರೆಕ್ಟೆಡ್ ದಿ ತಹಸೀಲ್ದಾರ್ ಕಂಡಕ್ಟ್ ದಿ ಸರ್ವೆ ಅಂಡ್ ರಿಪೋರ್ಟ್ ದಿ ಸೇಮ್. The ground malad, the respondent effect the kata on the basis of the forged document. The kata was challenged by the petitioner, filed appeal under section 136(2) of the land revenue before the assistant commissioner. On that, he himself directed the assistant commissioner Tahsildar to conduct the survey, my lord.
ಅಲ್ರಿ ಶಿವರಾಜು
Devaraj.
huh? Shivraju, who is Shivraju? Shivaswamy.
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 The grantee ಅಂದ್ಬಿಟ್ಟು.
Huh?
ಅವನು ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂದ್ಬಿಟ್ಟು ಖಾತೆ ಮಾಡಿಸ್ಕೊಡ್ತಾರೆ. That has been challenged before the Assistant Commissioner. Annexure F Malad under section 136 of it. ಇದರಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಮಾಡ್ತಾರೆ ಮಹಾಜನ್ ಮಾಡಿ. Annexure F Malad. Page number 30. The Kata was effected on the basis of the alleged grant dated TTCR 19/91/92. Grant ಆಗಿದೆ ಅಂದ್ಬಿಟ್ಟು ಖಾತೆ ಮಾಡಿಸ್ಕೊಡ್ತಾರೆ. That has been challenged by the petitioner.
How can he challenge it?
He is filed a form of 50 pending, Malad. Pending ಇದೆ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ನಮ್ಗೆ ತೊಂದರೆ ಬೇಡ. Trying to dispose of me by force of. I filed an application for form 50.
Correct, but the name of that Shivaswamy was there in the land revenue records.
Land revenue record is forged, man. The authority has issued. There is no grant at all. Earlier, Malad, this honorable court has directed the government to get the grant records. Government, this court has directed the authority to.
ಏನಾಯ್ತು before the assistant commissioner, what happened?
Assistant Commissioner set aside the memorandum of grant.
Which was made in the name of Shivaswamy.
Shivaswamy.
ಆಮೇಲೆ ಏನಾಯ್ತು?
Deputy Commissioner passed an order, injunction order.
So that
allowing the revision.
Shivaswamy's wife, Shakuntala.
The pendency of the petition appeal, Shivaswamy died. The loss was better. The Deputy Commissioner allowed the revision, Malad, page number 34. Adesha. ವಿಭಾಗಾದಿ ಆಸನ ಅವರ ಆದೇಶದ ಸಂಖ್ಯೆ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಿದೆ ಹಾಗೂ ಶಕುಂತಲಾ ಕೋರ್ ಶಿವಸ್ವಾಮಿ ಅವರ ಹೆಸರಿಗೆ ಖಾತಾ ಪುನರ್ಸ್ಥಾಪಿಸಿ ಆದೇಶಿಸಿದೆ ಹಾಗೂ ಶಾಂತಿಯುತ ಸ್ವಾಧೀನಕ್ಕೆ ಯಾರಿಂದಲೂ ಅಡ್ಡಪಡಿಸಿ ಶಾಶ್ವತವಾಗಿ ನಿರ್ಬಂಧಿತ ಆದೇಶಿಸಿದೆ. ಈ ಗ್ರಾಂಟೆಡ್ ದಿ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್. Taking advantage of the injunction order, they dispose of matter. Now, filed a complaint before the police. Police reached an FIR, produced the FIR copy on earlier occasion.
What is it that you want now? You have only filed an application that is not even considered. But that name of that Shivaswamy was there in the land revenue records from many years. How can you question that entry, sir?
I am in possession of property.
So, you are not the owner of the land.
No, he is also grantee under the form of 50.
By virtue of some grant set to have been made, his name has been entered.
Endorsement annexed. Grant ಆಗಿರೋದು endorsement ಕೊಡ್ತಾರೆ.
ಯಾರು?
ತಹಸೀಲ್ದಾರ್. Annexed page number 35.
How can he give an endorsement?
Grant records is not available. Grant records ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ annexed page number 35. Grant records ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ವಿ. ಓನ್ಲಿ ಇದನ್ನ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರೆ ಸಾಗುವಳಿ ಚೀಟಿನ they were not paid the premium. ಏನಿಲ್ಲ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅದಕ್ಕೆ Lordship kindly see the order sheet. Earlier occasion, this court has directed the get the grant records. Government
notice has not been ordered to the contesting respondent.
Yes, Malad.
ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ AG ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ get the records. ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಸಾಗುವಳಿ ಚೀಟಿ ಕೋರ್ಸ್ ಮಾಡ್ಕೊಂಡು ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ತದಲ್ಲ.
Issue notice to response number 6 to 8. Urgent notice to respond number 6 to 8 returnable by 25th of August 2022. ಬಂದಿದ್ಯಾ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ? In the meanwhile, the learned HCGP is also directed to secure the records from the fourth respondent, Tahsildar, Hassan Taluk, in respect of the grant said to have been made in favor of Sri Sivaswamy, the husband of respond number 6. Yes.
Status quo ఉంది.
ಏನ್ ಸ್ಟೇಟಸ್
ಅಲ್ಲ,
ಸರ್?
ತೊಂದ್ರೆ ಪಡ್ಲಿ.
ಏನ್ದ್ರದ್ದು ಸ್ಟೇಟಸ್ ಕೋ?
ಅಲ್ಲ, ನೋಡಿ, ತೊಂದ್ರೆ ಕೊಡ್ತಾರೆ.
ಯಾವ್ದ್ರದ್ದು ಸ್ಟೇಟಸ್ ಕೋ?
ಪೊಸಿಷನ್ಗೆ ತೊಂದ್ರೆ ಕೊಡಬಾರ್ದು. ಅವ್ರು ಬಂದು ಸ್ವಾಧೀನದಲ್ಲಿದ್ದಾರೆ ಎಲ್ಲ.
ಸರ್ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಖಾತೆ ಇದೆ.
ಇಲ್ಲ, ಖಾತೆ ಇಲ್ಲ, ರದ್ದಾಗಿದೆ ಅದು.
Sir, unless this court looks into all those records and comes to a conclusion,
ಅಲ್ಲ,
how can we
ಯಾರ್ ಸ್ವಾಧೀನದಿಂದ maintain status still.
that will give rise to a bigger dispute. ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Yes, let us see. You please come after 2 weeks. ಮಾಡಿ, whatever you want to do, you go and do that. Yes. Applicants.
Come on record as a petition number 2. I am the son of late Jairam. The property belongs to him. And I am the third wife's son. I have a right in the property. Therefore, I be implemented as one of the party to defend the petition.
You have been implemented.
No, my lord, my applications for impleading is spent.
Notice has been ordered.
I'm not, actually, I want to come as
ಅಲ್ಲ, ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ಎ ಮೇಲೆ?
petition number 2 ಆಗಿ ಬರಬೇಕು ಅಂತ.
ಹಾ. Where is the
ಅಲ್ಲ, ಇವ್ರು ಯಾರು? All
M. Saroja is appearing for the petitioner, is it?
petitioners. I am the son of Saroja.
Huh?
My
Who is-
father is late Jairam. He owns the property. And the
No,
fifth respondent,
who is appearing for the petitioner?
Jeevan Kumar, it appears he has given no objection. I think the
Huh?
papers are with me. It is Jeevan Kumar. Actually, I filed an application on 23rd
ನಿಮ್ಮ
February.
application ಅಲ್ಲ sir, the present petitioner, Srimati M. Saroja,
Was
who is
represented,
appearing?
represented by Jeevan Kumar. It appears he has given no objections.
No objection ಯಾರಿಗೆ?
Notice ಕೊಟ್ಬಿಟ್ಟು ಅವ್ರು ಬಂದಿಲ್ಲ.
ಅದು ಮೆಮೋ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ. That is not accepted still.
Yes. I'll file the call, my lord. I think the file is given to me.
Huh?
The applications, I filed the application on 23rd February 2022. my lord.
It's all right. If the petitioner has no objection, then you can come on record.
Yes, my lord. Yes, yes, ma'am. And in respect of other answered, I paid the process, my lord. Respond number 7. Short question, my lord. The respondent claiming to the
One ನಿಮಿಷ sir. You even before you come on record, if you start making submissions, now what can we do? ಅವ್ರಿಗೆ see by order dated 13/12/2021, the learned counsel is permitted to retire. And no notice also is issued to the petitioner.
I'll undertake.
ಮತ್ತೆ ಹೆಂಗ್ ಬರ್ತಾರ ಅವರು?
I'll undertake to file the wakala.
ಅಲ್ಲ, ಯಾರಿಗೆ?
Petitions.
ಸರೋಜಾ.
Saroja.
You undertake to file wakala.
Yes, yes.
Huh?
I'll undertake to file.
ವಕಾಲತ್ ಹಾಗೆ ಹೆಂಗ್?
Wakala.
Learned counsel Shri V. Krishnamurthy submits that since learned counsel Shri B.S. Jeevan Kumar, who was earlier appearing for the petitioner, is permitted to retire from this matter, he would undertake to file fresh wakalat for and on behalf of the petitioner. Full stop. Since next para, since IA number 1 of 2022 is also filed by the learned counsel, to implead Shri J. Pavan, son of late Shri K. Jairam, comma, the application also is required to be considered after appearance is entered on behalf of the petitioner hearing. Full stop. Next para. Release this matter on 18th of August 2022.
After this case, first matter, pertaining to land grant to the ex-servicemen. Directed. But, now, the government has issued a circular, my lord, where, my lord, we have issued a circular to all the deputy commissioners to give the number of land that has been allotted, granted.
Earmark.
Earmark, yes, my lord, with all the detail. And also, if the land is marked for the
Ex-serviceman.
And if there is any encroaches, what is the action that has been taken? We have issued a circular and we have sought for 4 weeks time from them to give all these details.
Allah, our details general now specific to this petition, there were already several directions.
In respect of one of the petitioners, the first petition, the deputy commissioner, the Tahsildar has given a document saying that there was only 2,864 acres of land that was demarked for the ex-servicemen. And those lands has already been granted to the ex-servicemen. They are in possession.
Allah, no, you are on record saying that some of the areas reserved for ex-servicemen is in possession of unauthorized person, and we are taking action to evict them. You are already on record. How can you now make a submission that no, there is no one?
That what has happened, my lord, one of the issue, my lord, the revenue authorities, my lord, the revenue secretary, my lord, now he himself has issued this circular to all the deputy commissioners.
See, that was in view of my previous order. That is a general directions. That is all right. But specifically, we have recorded so in the previous order.
Once we get this information, my lord, if there is any encroachment, and the Sutala says you have to take action to issuing notice and proceed with evicting the unauthorized occupants if they are in the possession of demarked area for the ex-service. That is what this circular says.
Correct, but in the present case,
it includes for all the survey numbers.
Sir, but you had already given an undertaking before this court in respect of these petitioners, in respect of that particular district. Yaudadu?
Dated 88/11/2019. There was an order.
ಈಗಾಗಲೇ 4-4 ಸರಿ ವಾಯ್ದೆ ಆಗೋಗಿದೆ.
The committee has been constituted now because by the workshop, my lordship order, all the details of the committee has been constituted, where the principal secretary is also one of the chairperson of that committee. But we are only trying to ascertain if there is any land that has been granted the MR for the ex-servicemen, and if there are any encroachers, we are trying to take action within 4 weeks to evict them and trying to allot the land to the ex-servicemen. That is what this is.
Okay.
My lord, in the serial number 23-24, Mysore district deputy commissioner himself is given a endorsement. There is a 3,385 acres of land was reserved for ex-servicemen, and out of which 2,236 Annexure C is the document which I have produced before this honorable court. It is a 2002 matter. They have admitted 381 ಜನರುಗಳು 734 ಎಕರೆ ಜಮೀನನ್ನು ಅನಧಿಕೃತವಾಗಿದ್ದಾರೆ. Without evicting them, want to make wrongful gain.
may kindly see the order dated 3/6/2019. My DC of Mysore was present for this court personally, and he was specifically directed. He is called upon to submit his report with reference to the total extent of land reserved under the aforesaid government order, out of which the extent of land which is granted in favor of the applicants who have served the nation during the Second World War and thereafter, extent of land which was available to the government, out of which extent of land under unauthorized document, which was considered for grant in the 1977 and 1991, shall be furnished by him within 2 weeks from today. That was the order passed in 2019, 3 years ago. Again, the same undertaking is being given.
Eight eleven 2019.
3/6/2019. Other than that, order ಆಗಿದೆ. Federal Secretary was present before this court for 3-4 occasions. DC of Mysore was present before this court.
So, which are the districts involved in the present case? Which are the districts? Huh? Mysore, Hasan, Chikmagalur, Bangalore, rural district.
The difference is not. In certain districts, there are land reserved. Already reserved. So far as Mysore is concerned, there are already as admitted by DC, there are 2,236 acres reserved. In certain districts, it's not reserved.
Hasan, Mysore,
Bangalore rural district also, my lord.
Nalakena?
Bangalore rural district also.
Sorry, I'm told that there is a flood of application under the regulation. They have been instigating the unauthorized document to file the application.
ಅಲ್ಲ ಮಾಡ್ಕೊಂಡ್ಲಿ ಸಿ 10% was to be reserved for grant to ex-servicemen. We are not concerned with the other. So therefore,
here is the case. 3,385 acres, entire acre was reserved for ex-servicemen only.
Therefore,
This
in
land is
terms
not-
of that rule, if these lands were reserved for ex-servicemen,
Ex-servicemen only because
we
of-
have directed them there to remove all unauthorized occupation and grant it. learned AGA has filed a memo along with either original, please write the date hakilan. Along with a circular dated 10/8/2022 issued by Principal Secretary, Revenue Department, and a communication dated 10/8/2022 made by the Principal Secretary, Revenue Department, to all the regional commissioners and deputy commissioners of all the districts, bringing to their notice the orders passed by this court on 28/7/2022, and it has been directed that action shall be initiated by the concerned deputy commissioners to remove all unauthorized occupations of the lands reserved for grant in favor of ex-servicemen within a period of 1 month from the date of the circular. Stop. Communication dated 10/8/2022. It is stated that the deputy commissioners are required to upload information regarding the action taken for evicting all unauthorized occupants of the lands reserved for grant to ex-servicemen. Email dash SO full stop LG stop RD at the rate of gmail.com. In a period of 1 week, so that the information is made available to the general public. Stop. Next para. Whatever data. A copy of the, have you served a copy of the same is served on the learned counsels for the petitioners. Stop. Para. Having gone through the circular dated 10/8/2022 and the communication of the Principal Secretary, the event date, this court finds that steps have been taken by the state government to remove all unauthorized encroachments made on lands reserved for grant in favor of ex-servicemen. So, nevertheless, for immediate action, what is required on the part of the respondent state government is in respect of five districts, namely Chikmagalur, Hassan, Kodagu, Mysore, and Bangalore rural district. So it is noticeable that several interim orders have been passed by this court in respect of the above 5 districts. And there has been no compliance of the directions issued by this court for more than 3 years. Stop. Nevertheless, since a week's time is granted in terms of the circular dated 10/8/2022, Revenue Department to all the concerned deputy commissioners to upload information for evicting unauthorized occupations made on lands reserved for ex-servicemen, it is expected that at least in respect of the 5 districts named herein above, positive information will be made available to this court that all such unauthorized occupations have been removed consequent to the circular issued by the state government. Stop. Released this matter on 22nd of August 2022.
May make one
the learned AGA to furnish information on the action taken consequent to the circular dated 10/8/2022 in respect of the 5 districts mentioned herein above. Stop. Yes.
May make one. Udupi district is also involved in the risk. Your lordship may seek your lordship. Udupi district is also involved in the one of the 10,955. Much obliged, my lord. Sorry, because your lordship dictating it, therefore I don't want to interrupt it.
Yes.
I made a submission after you are closing it, my lord.
Huh?
10,955 is from Udupi.
ಅದನ್ನ ಆಗ್ಲೇ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಆಕ್ಷನ್ ಟು ಬಿ ಟೇಕನ್ ಫಾರ್ ಗ್ರಾಂಟ್ ಆಫ್ ದಿ ಲ್ಯಾಂಡ್ಸ್ ರಿಪೋರ್ಟೆಡ್ ಟು ಬಿ ರಿಪೋರ್ಟೆಡ್ ವಿತ್ ಇನ್ 1 month ಅಂದ್ಬಿಟ್ಟು ಅವರೇ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ದಿ process would have already commenced. But I have noticed that in all these cases, there is a specific contention that the lands have been encroached. And therefore, it has to be removed if it has to be granted to you. Available directions you take action and grant the lands within 1 month. Yes. Allaba, nimma communication prakara 1 week's time is granted. Haudu, namge ashtare saku. If you say that it has been evicted and within 1 week that information is uploaded, then we will give directions to allot the grant the lands. Alva, I have given more than 1 week. Yes. Second.
Well, the NOC local, still previous advocates and record, their names have been deleted. Maybe names may be deleted from the house list. Elections may be done. Now, the petitioner,
What was the direction given last time? A copy is served on you.
copy is served on me, Lord. May I make the submission? Lord?
Learned counsel for the petitioner accepts, admits that a copy of the affidavit dated 4/8/2022 of the Tahsildar, Bangalore South Taluk is served on the learned counsel.
Lord, the petitioner is before this honorable court, seeking writ of mandamus, directing the respondent 1 to 5 to evict the encroacher, the respondent number 6. Just come to page number 22, my lord, annexure C. 22, sir. I read the annexure C, sir. I read it, my lord.
Yes.
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಮನವಿಯಲ್ಲಿ ಮಂಚನಬೆಲೆ ಜಲಾಶಯಕ್ಕೆ ಮುಳುಗಡೆಯಾಗಿದ್ದು, ಇದಕ್ಕೆ ಪರಿಹಾರವಾಗಿ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೋಲೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 48, 50, 56, 57 ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನಿಗೆ ಹಕ್ಕುಪತ್ರ ನೀಡಿದ್ದು, ಸದರಿ ಹಕ್ಕುಪತ್ರದಲ್ಲಿ ಮೇಲ್ಕಂಡ 4 ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ಹಾಕಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿನಲ್ಲಿ ಅನುಭವಿಸಲು ಸಾಧ್ಯವಾಗದೆ ಸಂಕಷ್ಟದಲ್ಲಿರುತ್ತೇವೆ. ಆದ್ದರಿಂದ ಯಾವ ಜಮೀನಿಗೆ ಹಕ್ಕುಪತ್ರ ನೀಡುತ್ತಾರೆ ಎಂದು ಜಮೀನನ್ನು ಗುರುತಿಸಿ ಚೆಕ್ಕುಬಂದಿ ಮಾಡಿಸಿಕೊಳ್ಳಲು ಕೋರಿರುತ್ತಾರೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ರಲ್ಲಿ ವರದಿ ಪಡೆಯಲಾಗಿ ಸದರಿ ವರದಿ ಕೋಲೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 48, 50, 56, 57 ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನು ಚೆಕ್ಕುಬಂದಿ ಗುರುತಿಸುವ ಬಗ್ಗೆ ತಾಲೂಕು ಮೋಜಣಿದಾರರ ನಕ್ಷೆ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಅರ್ಜಿಯನ್ನು ತಾಲೂಕು ಮೋಜಣಿದಾರರಿಗೆ ರವಾನಿಸಲು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ವಿಚಾರಗಳಿಗೆ ಈಗಾಗಲೇ ಉಲ್ಲೇಖ 4 ರಲ್ಲಿ ಅಳತೆ ಮಾಡಿ ವರದಿ ನೀಡಲು ಸೂಚಿಸಲಾಗಿತ್ತು, ಆದರೆ ಈವರೆಗೂ ವರದಿ ನೀಡಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ಕೋಲೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 48, 50, 56, 57 ರಲ್ಲಿ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನಿನ ಬದಲಿಯಾಗಿ ಜಮೀನಾಗ ನೀಡುತ್ತಾರೆ ಎಂಬ ಬಗ್ಗೆ ಸ್ಥಳ ಪರಿಶೀಲಿಸಿ ಅಳತೆ ಮಾಡಿ ಚೆಕ್ಕುಬಂದಿಯೊಂದಿಗೆ ನಕ್ಷೆ ತಯಾರಿಸಿ ಅತಿ ಜರೂರಾಗಿ ವಾಸ್ತವಾಂಶದ ವರದಿ ನೀಡಲು ಮತ್ತೊಮ್ಮೆ ಸೂಚಿಸಿದೆ. ಈ ಡೈರೆಕ್ಟ್ಸ್ ಟು ದಿ ಸರ್ವೇಯರ್ ಮೆಲಾನ್, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಮೆಲಾನ್. Here next annexure D ಮೆಲಾನ್ is the survey sketch ಮೆಲಾನ್ prepared by the surveyor, which is on page number 24 ಮೆಲಾನ್. ಟಿಪ್ಪಣಿ ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಈ ಬಗ್ಗೆ ಸೋರಿಸಿರುವ ಸರ್ವೆ ನಂಬರ್ 56 ರಲ್ಲಿ 1 ಎಕರೆ ಆದೇಶವಾಗಿದ್ದು, ಸದರಿ ಜಮೀನನ್ನು ಮಂಚನಬೆಲೆ ಜಲಾಶಯಕ್ಕೆ ಮುಳುಗಡೆಯಾಗಿದ್ದು, ಇದಕ್ಕೆ ಪರಿಹಾರವಾಗಿ ಪುಟ್ಟಯ್ಯ ಬಿನ್ ಜಡಿಯಪ್ಪ ಎಂಬುವರಿಗೆ ಕೋಲೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 45, 50, 56, 57ರಲ್ಲಿ ಸಂಖ್ಯೆ ಅಧಿಕೃತ ಜ್ಞಾಪನ 5138 of 1983-84 ದಿನಾಂಕ 8/9/94 ರಂತೆ ಸಾಗುವಳಿ ಪತ್ರ ಕೊಟ್ಟಿರುವುದು ಸರಿಯಷ್ಟೇ. ಸದರಿ ಪುಟ್ಟಯ್ಯ ಎಂಬುವರು ಪಾವತಿಯಾಗಿದ್ದು, ಮಗನಾದ ಶಾಂತಾನಂದ ಮೂರ್ತಿ ಪುಟ್ಟಯ್ಯ ಎಂಬುವರ ನಿಖರವಾಗಿ ಸರ್ವೆ ಸಂಖ್ಯೆ ಹಾಗೂ ಚೆಕ್ಕುಬಂದಿ ಗುರುತಿಸುವ ಬಗ್ಗೆ ಅರ್ಜಿ ಕೊಟ್ಟಂತೆ ಅರ್ಜಿ ನಂಬರ್ ಸೋನ್ಸೋ ಸ್ಕೆಚ್ ತಯಾರಿಸಿ ಜಮೀನನ್ನು ಚೆಕ್ಕುಬಂದಿ ಸರ್ವೆ ಸಮೇತ ನೀಡಿದೆ, ತರಿಸಿದೆ ಅನ್ನೋದು. ಸದರಿ ಜಮೀನು ಸನ್ಮಾನ್ಯ ಎ.ಟಿ. ರಮಣಸ್ವಾಮಿ ಅಯ್ಯರ್ ಆಯೋಗದ ನಕ್ಷೆಯಂತೆ ಬ್ಲಾಕ್ ನಂಬರ್ 35 ರಲ್ಲಿ 1 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನನ್ನು ಹನುಮಯ್ಯ ಎಂಬುವರು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದು ಅನುಭವದಲ್ಲಿ ಇರುತ್ತಾರೆ. ಹಾಲಿ ಜಮೀನಿನ ಸ್ಥಿತಿ ವ್ಯವಸಾಯ ಮಾಡಿರುವ ಗುರುತುಗಳು ಸಹ ಕಂಡು ಬಂದಿರುತ್ತೆ. ಸದರಿ ಒತ್ತುವರಿ ತೆರವುಗೊಳಿಸುವ ನಂತರ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಬಹುದಾಗಿರುತ್ತದೆ ಎಂದು ಈ gives the report ಮೆಲಾನ್. And subsequently respondent Tahsildar writes to in our annexure E ಮೆಲಾನ್, page number 26, ಸೆಕೆಂಡ್ ಪರಸಮೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 2, 3 ರಲ್ಲಿ ವರದಿ ಪಡೆಯಲಾಗಿ ಸದರಿ ವರದಿಯಲ್ಲಿ ಕೋಲೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 48, 50, 56, 57 ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನು ಚೆಕ್ಕುಬಂದಿ ಗುರುತಿಸುವ ಬಗ್ಗೆ ತಾಲೂಕು ಮೋಜಣಿದಾರರಿಂದ ನಕ್ಷೆ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ. ಆದರೆ ಸದ್ಯ ರಾಜ್ಯವು ತಾಲೂಕು ಮೋಜಣಿದಾರ ರವಾನಿಸಲು ವರದಿ ನೀಡುತ್ತಾರೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 4 ರಲ್ಲಿ ತಾಲೂಕು ಮೋಜಣಿದಾರರು ನಕ್ಷೆಯೊಂದಿಗೆ ವರದಿ ನೀಡಿರುತ್ತಾರೆ.
ಹನುಮಯ್ಯ
Anumaya is the enclosure.
Unauthorized.
House. So ಇದರಂತೆ ಸದರಿ ವರದಿಯಲ್ಲಿ ತಾವರೆಕೆರೆ ಹೋಬಳಿ ಕೋಲೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 56ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನನ್ನು ಮಂಚಿನಬೆಲೆ ಜಲಾಶಯಕ್ಕೆ ಮುಳುಗಡೆಯಾಗಿರುವ ಜಮೀನಿಗೆ ಬದಲಿಯಾಗಿ ನೀಡಿರುವ ಜಮೀನಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಎಟಿ ರಾಮಸ್ವಾಮಿ ಆಯೋಗದ ನಕ್ಷೆಯಂತೆ ಬ್ಲಾಕ್ ನಂಬರ್ 34 ರಲ್ಲಿ 1 ಎಕರೆ 10 ಗುಂಟ ಜಮೀನು ಅನುಮಯ ಎಂಬುವರು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಅನುಭವದಲ್ಲಿರುತ್ತಾರೆ. ಹಾಲಿ ಸ್ಥಿತಿಯಿಂದ ವ್ಯವಸಾಯ ಮಾಡಿರುವ ಗುರುತು ಸಹ ಕಂಡು ಬಂದು ಒತ್ತುವರಿ ತೆರವುಗೊಳಿಸಿದ ನಂತರ ಕ್ರಮ ಜರುಗಿಸುತ್ತದೆ ಎಂದು ವರದಿ ನೀಡುತ್ತಾರೆ. ತಾಲೂಕು ಮನವಿದಾರರ ವರದಿಯಂತೆ ಮೇಲ್ಕಂಡ ವಿಚಾರದ ಬಗ್ಗೆ ಸ್ಥಳ ಪರಿಶೀಲಿಸಿ ಒತ್ತುವರಿದಾರರ ವಿವರದೊಂದಿಗೆ ಹಾಲಿ ವಾಸ್ತವಾಂಶವನ್ನು ನೀಡಲು ಸೂಚಿಸಿದೆ. ಈ ರೈಟ್ಸ್ ಉಪ ತಹಸೀಲ್ದಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4. And then next, which is important, annexure F.
So land has been granted to you.
Granted.
Your father.
Absolutely. Petitioner's father, my lord. He is no more. Let me make the complete by some.
You are both ಅವರು. No.
Let me complete.
Page number 25 ಅಲ್ಲಿ 4ನೇ ಲೈನ್ ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ 5138/8384 ದಿನಾಂಕ 8/9/84ರಂತೆ ಸಾಗುವಳಿ ಪತ್ರ ಕೊಟ್ಟಿರುವುದು ಸರಿಯಷ್ಟೇ.
Peter, will come to that later. It is completely contrary to the records, documents placed on by the petitioner before the honorable court. There is every possible document I have placed before the honorable court.
One acre each will be allotted. Displaced persons. But do you accept that he is also a project displaced person? And then why have you not granted then? ಆಯ್ತು. Your respond number 6. Sixth respondent. ಆಯ್ತು ರೀ, when you say he is an unauthorized occupant, why are you not evicting him? ಮಾಡಿ evict ಮಾಡ್ಬಿಟ್ಟು ಇವ್ರಿಗೆ ಕೊಡಿ. Why not, sir? Why not? When he is saying it was identified and from one of your records, it is found that in fact Sagavali chit was issued. Even if it is not issued, why not? Why don't you evict and give that same land to him? What is the problem? It is the contention of the petitioner that although 1 acre of land in survey number 56 of
Kolur village,
Kolur village, Tavarekare
block number
Hoadli.
37, block number 35. Survey
Was-
number 56, block number 35, sir.
Survey number block number 35 was identified to be granted to the petitioner's father, late Sri Puttaya,
Also,
who was a project displaced person of Manchanabele Dam, and a Sagodi chit dated 8/9/1984 was issued in terms of official memorandum bearing number 5138 of 83/84. Nevertheless, it appears that the sixth respondent is in unauthorized occupation of the same. Stop. Learned ATA submits that after verification from the records, it is found that no such grant order as suggested by the petitioner in official memorandum bearing number so and so dated so and so is made in favor of Sri Puttaya. Stop. Such an order is not found in the records. Full stop. Numbers 48, 50, 56, and 58. 57 56 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲಿ.
survey number. ಇಲ್ಲ 58 ಇಲ್ಲ 48, 50, 56, 57.
48, 50, 56, 58.
57, sir.
56 ಇಲ್ವಾ? 57. 58 ತೆಗೆದಾಕಿ 57 ಮಾಡಿ. ಏನಿದೆ?
And AJ would further submit that action has been initiated by the state authorities to remove the unauthorized encroachment made in survey number 48, 50, 56, 57.
By moving the special code for land grabbing, and the proceedings are pending before the special court. Stop. ಯಾವ್ದು ಇದು ನಂಬರ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? Please furnish that number. Next para. Having regard to the grievance of the petitioner, this court is of the considered opinion that the proceedings before the special court for land grabbing is required to be expedited. Full stop. Therefore, this court would request the special court for land grabbing to consider and dispose of the dispute in number so and so pertaining to survey number 56 of Kolur village,
Block number 35.
block number 35.
Would request the special court for land and consider and dispose of the dispute in so and so number pertaining to survey number 56 of 56, block number 35 of Kolur village.
As expeditiously as possible. Stop. Release this matter on 12th of September 2022. Full stop. Learned. Next para. The Registrar Judicial is directed to convey this order to the Special Court for land grabbing. Yes. Let us see. If they pass orders, then we can. Yes.
Previous advocates on record for petitions may be deleted.
Next para. Since learned counsel, Sri Annapurna Bevinje
And Chandrasekhar acquired the inverse vehicle from
Chandrasekhar. Since learned counsel Sri Chandrasekhar is appearing for the petitioner, in the name of the learned counsel Sri Sharat AS and Srimati Annapurna Bevinje may be removed from the cause list.
I for deletion of respond number 8A and respond number 9. I filed an application. I've taken out notice of it 3 times, my lord. The same has been written as answer. So I had filed this application to deletion of the respond number 8 in the IAs and the respond number 9 is in writ petition.
Then you had no grievance against the said respondent.
No, my lord, only for the respond number 8, my lord. Have been died in the year 2014, my lord. Date of my knowledge, my lord, the notice has been issued by the respond number 8. I have the information I got in information, the respond number 8 has been died in the year 2014. And I had filed an applications in LR's application of respond number 8 and the delay application I had filed, and also a abatement of the
You are seeking deletion of
respond number 8A in IS mine and also a respond number 9.
respondent number 9.
Yes, ma'am.
Why,
my lord, I had mentioned in the address shown as in the revenue authority. I had taken that same address, my lord, but the
I understood that you are not able to serve.
yes, my lord.
But if you had no grievance against them, why did you make them parties here?
Because of the respond number 8 is the owner of the suit scheduled property.
Our respond number 8 is no more.
No more.
You have filed an application.
Yes, my lord. The LRs of the respond number 8 is the 8A, my lord.
You have filed an application for substituted service.
Yes, my lord. That application has been rejected.
Rejected.
Yes, my lord.
Where is your application to bring the LRs on record then?
But I had filed on the date 21 May 2020, my.
And notice was not ordered on that IA?
It has been ordered, my lord, but same has been answered, my.
A is Srimati Muniratnam.
is the LRs of the R8, my
Why you are seeking deletion now?
division, my lord, I had taken in 3 times.
But then if you don't bring all the LRs, then what kind of an order can be passed?
The respond number 8 is the rights of the title over the property until or rotational entry agide. Respond number 8. So
ಈಗ ಅವರ LRs ನ ನೀವು ರೆಕಾರ್ಡ್ ತರಲಿಲ್ಲ ಅಂತಂದ್ರೆ what order can be passed by this court?
I am the purchaser of the
Why are you asking for deletion of 8A ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ?
ಯಾಕಂದ್ರೆ ಅವರು
ಸರ್ವಿಸ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಡಿಲಿಷನ್ ಕೇಳ್ತಾ ಇದೀರಾ. Then what is the consequence then?
Consequences ಅಂದ್ರೆ ಸ್ವಾಮಿ ಅವ್ರನ್ನ ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ ಮುಂದೆ ಅವ್ರನ್ನ
they will attack your order. Even if this court passes an order, they'll say all the LRs were not brought on record anta. How can you ask for deletion of this name? Why your application for taking out paper publication was rejected?
Paper publication has been rejected for the correct address ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿ paper publication has been rejected.
ಆಯ್ತು, ತಗೋಬೇಕಾಗಿತ್ತು.
ನಾನು ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ರೆವಿನ್ಯೂ ಅಥಾರಿಟಿ
See, the law requires that you will have to take out notice at least for 3 times.
ತಗೊಂಡಿದ್ದೀನಿ 3 times ತಗೊಂಡಿದ್ದೀನಿ.
ಆಮೇಲೆ we could have allowed the application for paper publication.
I filed a paper application. 5/3/2022 ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಪ್ಲಿಕೇಶನ್.
ಮಿಕ್ಕಿದವರಿಗೆ A, B2 ಈ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಈ ತರ ನೀವು ಶ್ರೀಮತಿ ಮುನಿರತ್ನಮ್ಮ ದೊಡ್ಡ ಬಾಣಸ್ವಾಡಿ ಬೆಂಗಳೂರು ಅಂತ ಅಂದ್ರೆ ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ ಅಮ್ಮ, ಇದು ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ ಇದು
ಅಲ್ಲ, ಅಲ್ಲಿ ಅವ್ರ ಅಡ್ರೆಸ್ ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಒಂದ್ ಸ್ವಲ್ಪ ಕಷ್ಟಪಟ್ಟು ಹೋಗಿ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ತಗೊಂಡ್ಬರಕ್ ಆಗಲ್ಲ ನಿಮ್ ಕೈಲಿ. ಆ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗುತ್ತಾ? ಇದೇನು ಹಳ್ಳಿ ಅಲ್ಲ, ಇದು ಹಳ್ಳಿಲಾದ್ರೆ ಈ ತರ ಆಗ್ಬೋದು. Instead of giving the correct address, you are making all sorts of applications which are illogical. If you seek deletion of this party, then they will attack the order of this court also on the ground that all the LRs were not brought on record. Then how can you make this kind of an application? You furnish the correct address. IA number 1 of 2022. IA number 2 of 2022. 2 of 22 for deletion.
For deletion.
And what about respond number 9? Why are you seeking deletion? Same reason, huh?
Same reason.
You'll have to furnish correct address. IA number 2 of 2022 is permitted to be withdrawn as not pressed. Next para, the petitioner is granted 2 weeks time to furnish the correct address for service of notice on the proposed respondent number 8A and respondent number 9. Yes, please get the correct address and we will direct notice. More sari ತಗೊಳ್ಳಿ, ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ then we will permit you to take out paper publication. Yes. ಏನ್ ಹೆಸರಿ ಕೇಳ್ತೀರಿ ಟೈಮು? Finally, a week's time is granted at the request of learned counsel for petitioner for complaints of office objection. Yes.
27, my lord, I am for the petitioner in this case. Lord, I have filed an application for my lord bringing LRs of my lord deceased respond number 4.
Notice order ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
Notice order ಆಗಿದೆ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ.
Notice order ಆಗಿದೆ?
ಆಗಿಲ್ಲ
Issue
ಸರ್,
notice.
ಮಾಡ್ಬೇಕು.
On IA number 1 of 2022.
Lord, interim order may kindly be extended.
Interim order granted earlier stands extended till the next date of hearing.
Obliged.
Your Honor, I appear for the petition in this case. This is actually attended by my colleague and he's not able to attend today because of a medical emergency at his case. He's seeking for 2 weeks time. However, he instructed me that all the objections were complied with, and these are the new set of objections. So he will look into it once he's back.
Finally, a week's time is granted for complaints of office objection.
I filed an application. I am for the impleading applicant.
You impleading
Continuation of
applicant.
delay,
Impleading applicant
please.
as respondent.
Petitioner, sole petitioner died.
Ah,
I am the son of the petitioner. In the last occasion, I have not mentioned the days of delay in the application. That is the reason.
mention madidara.
Mentioned it.
417 days. Put one copy for the. We'll allow this application. They have to bring themselves on record on behalf of the sole petitioner. Orders on IA number 123 of 2022. These applications are filed. By Shri Purushottam Reddy. Our Obre Varadar.
Brother and sister is there. Last occasion I
You said,
mentioned.
yes. Purushottam Reddy. To come on record as legal representative of the sole deceased petitioner, Srimati P.S. Vimalamma. Stop. There is a delay of 417 days in filing the application. Stop. Next para. It is also stated in the affidavit accompanying the application that Srimati P.S. Vimalamma died on 3/5/2021, leaving behind 3 children, namely Sri Purushottam Reddy, Sri Prakash Reddy, and children. Prakash Reddy and no bro. Yakri ಹೆಸರು ಬರ್ತಿಲ್ಲ. And a daughter. So, however, since the other 2 siblings of the applicant have come forward to file an application to come on record, the impleading applicant, Sri Purushottam Reddy, has alone filed these applications. Stop. Next para. on going through the reasons furnished in the affidavit accompanying the application, and this court being satisfied with the explanation offered, the delay is condoned and abatement is set aside. Full stop. Consequently, the application is allowed while permitting the applicant to come on record as a legal representative of the deceased petitioner, Srimati P.S. Vimalamma. So, learned counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Next para. As noticed herein above, comma, there are 2 more legal heirs of Srimati P.S. Vimalamma. Full stop. As and when application is filed by the said persons, comma, this court would permit them to come on record as legal representatives of Srimati P.S. Vimalamma, comma, failing which the petitioner is permitted to file another application to bring the said 2 persons as party respondents to these proceedings. Yes.
2 weeks. 2 weeks.
Okay.
4-5 days I have some function.
2 weeks.
Yeah.
We'll continue at 2:30.
Please go.
Sir, court officer. Court officer. ಸ್ವಂತ ಊರು ಯಾವ್ದ್ರೆ? ಬೆಂಗಳೂರಲ್ಲಿ ಎಲ್ಲಿ ಆಂಧ್ರದಲ್ಲಿ? ಚಿತ್ತೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್. ಚಿತ್ತೂರು ತಿರುಪತಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ ಎಲ್ಲ ನಿಮ್ ಯಜಮಾನ್ರು ಫೋನ್ ತೆಗಿತಾ ಇಲ್ಲ, ಅಷ್ಟು ಕೊಟ್ಬಿಟ್ಟು ಬರಕ್ ಹೇಳಿರತ್ತಾನೆ. ಹೆಂಗ್ ಬಂದಿದ್ದೀರಾ ನೀವು? ನೋಡಿ.
Oh, who's on the other side?
Lawyers including
You idira?
Appearing for the 37 respondents contesting this one. Start date may mainly be according to the convenience of the the 10 connected measures.
We'll have it on 25th then. 25th of August. At the request of learned Additional Advocate General, release these matters on 25th of August 2022 at 2:30 p.m. Yes.
Approval matter, till number 10. Yes, you can take order.
Yes. The revenue entries relating to survey number 110/1 were made in the name of petitioners on the basis of civil court decree in RA. Lakshmi kindly see annexure B. This is a decree that was drawn in favor of petitioners.
That was in 2006.
2006. The entries mutation also was made as per MR. Page 50, annexure C. Really, ಎರಡ್ ಸರ್ವೆ ನಂಬರ್ 45/2 ಮೇಲೆ ಇದೆ. Page 50. ಮೇಲೆ 45/2 ಇದೆ, ಅದು ಕೆಳಗಡೆಗೆ 110/1 ಇದೆ. Were made in the name of Munsidamma, petitioner here. Petitioners ಅದು mother of the petitioners. And ಆಮೇಲೆ ಅಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆದೇಶದ ಪ್ರಕಾರ ಅಂತಾನು ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಹಕ್ಕು ಬಿಡುಗಡೆ ಅಂತ ಅದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. The revenue entries were transferred in their name. And it is continued up to 2016-17. In 17, they filed the respondents herein filed appeal before the assistant commissioner, in which notices were not served. ಅದು ಒಂದ್ ದಿವಸ ನೋಟಿಸ್ ಬಂದ ತಕ್ಷಣ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಂತ ತಗೊಂಡಿದೀವಿ, ಹಾಗಾಗ್ಬಿಟ್ಟು ಆರ್ಡರ್ಸ್ ಪೋಸ್ಟ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿ ಅವ್ರು ಮಾಡ್ಬಿಟ್ಟು ನಾವು ಅದರಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ವಿ. Against that, we filed an appeal revision petition before.
What is it? What is the ground on which they sought remove your name?
They claim that in the year 1924 there is a document in their favor. On that basis, they are the owners of this land. From the beginning, the revenue interest was stood in our name, in the name of petitioner's father, grandfather. And the deputy commissioner, in page 50, 61, Lakshmi kindly see. 5960.
This ex parte order was passed by the assistant commissioner.
Yes, that order, even after bringing the notice that this revenue entries were not made on the basis of any hakku bidugade patra, it is on the basis of civil court order. He says that this is made on the hakku bidugade patra only with respect to survey number 45/2. There is no such indication with respect to 110/1. For that reason, this has been dismissed and appeal has been dismissed. And also he states that because the matter has been remanded back to Tahsil for fresh consideration. No such fresh consideration. Immediately after remand, the matter has been, the revenue entries have been changed in their name. That we have challenged before this honorable. The order on its face, both the authorities illegally passed this order behind.
Please read the order of the assistant commissioner.
Yes. Page 50.
Operative portion.
Yes, page 55. ಮೇಲ್ಮನವಿದಾರರ ಮನವಿ ಆಗೋ ಲಿಖಿತ ಆಗೋ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ವೀರಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 110/1ರಲ್ಲಿ 37 ಗುಂಟೆ ಖಾತೆಯನ್ನು ಪಾಣಿ MR ಸೋ ಪಾಣಿ ದಾಖಲೆ ಮಾಡಿಸಿಕೊಂಡು ಕಂಡು ಬರುತ್ತೆ. ಆದ್ರೆ ಮ್ಯುಟೇಷನ್ ಸಂಖ್ಯೆ MRH 20/2001 ಪರಿಶೀಲಿಸಲಾಗಿ ಮ್ಯುಟೇಷನ್ ಆದೇಶವು ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ವೀರಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 45/2ರಲ್ಲಿ ಮುನಿಸಿದ್ದಮ್ಮ ಸಿದ್ದರಾಮಕ್ಕ ಬಿನ್ ಮುನ್ಶಾಮಪ್ಪ ಅವರಿಗೆ ಹಕ್ಕು ಬಿಡುಗಡೆ ಆಧಾರದ ಮೇಲೆ ಮಾಡಿದ್ದು. ಸರ್ವೆ ನಂಬರ್ 110 37 ಗುಂಟೆ ಪಾಣಿ ದಾಖಲು ಮಾಡಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿದೆ. ಆದುದರಿಂದ ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ವೀರಾಪುರ ಗ್ರಾಮದ 110 37 ಗುಂಟೆ MR ಸೋ ಸಂಬಂಧಪಟ್ಟು ಮಾತ್ರ 2ನೇ ಪ್ರತಿವಾರಿಗೆ ದಾಖಲೆಯನ್ನು ವಜಾಕರಿಸಿದೆ. ಆ ಪಾಣಿನಲ್ಲಿ 2ಕ್ಕೂ ಮಾಡಿದ್ದೀವಿ, ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆದೇಶ ಬರ್ದಿದ್ರು ಈ ತರ ಎರೋನಿಯಸ್ ಆಗಿ ಹಾಗೂ ಪ್ರಕರಣವನ್ನು ತಹಸೀಲ್ದಾರ್ಗೆ ಹಿಂದಿರುಗಿಸಿ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಮೇಲೆ ಸ್ವಾಧೀನವನ್ನು ಪರಿಶೀಲಿಸಿ ಸೋ ಮೇಲ್ಮನವಿಗೆ ಸೋ ಖಾತೆಯನ್ನು ವರ್ಗಾಯಿಸಲು ಆದೇಶಿಸಿ. ನಾನು ಕಾನೂನು ಪ್ರಕಾರವಾಗಿ ಹೋಗ್ಲಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಅಂತಾನು ಹೇಳಿ ಅವ್ರ ಆದೇಶಕ್ಕೆ ಇದ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ನಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ಲಿಲ್ಲ, ಏನಿಲ್ಲ, ಇಮಿಡಿಯೇಟ್ಲಿ ದೇ ಹ್ಯಾವ್ ಚೇಂಜ್. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅವರು ಹೋಗ್ಲಿ ಅವ್ರೇನೋ ತಪ್ಪು ಮಾಡಿದ್ರು, ಗಮನಕ್ಕೆ ತಂದ ಮೇಲೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆದೇಶ ಇದೆ ಅನ್ನೋದನ್ನ ಲೆಕ್ಕಕ್ಕೆ ತಗೊಳ್ಳೋದೇ.
There is no one for this caveator?
ಇಲ್ಲ.
Learned AG takes notice for response number 1 to 4. Learned Counsel Shri Manjunath Reddy has entered appearance for response number 5 and 6 by filing a caveat notice to response number 7 to 12. Learned Counsel for the petitioner is directed to serve a copy of the petition on the Learned AGA. Next para. Learned Counsel for the petitioners submits that in terms of
Civil court decree, page 35 annexure.
where is that?
Page 35 annexure B.
It's a compromise decree.
Yes. That Malad Munsidamma is appellant number 2.
Where is the
Shares,
where is the judgment and decree of the trial court?
the decree alone I have produced. Judgment and decree are not produced. I will undertake to produce. On page 48 ಅಲ್ಲಿ ಅವ್ರು ಶೇರ್ ಕೊಟ್ಟಿರೋದು ಇದರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 2 ಬಂದು ಅದರಲ್ಲಿ ಮುನಿಸಿದ್ದಮ್ಮ, ಇವರು ಪಿಟಿಷನರ್ಸ್ ಗ್ರ್ಯಾಂಡ್ ಮದರ್.
The contesting respondents are not party to the proceedings.
They are not parties. They are no.
So that is why they are contending that though we had rights in the land, they have clandestinely entered into a compromise petition and they have got this decree, and that is their contention.
Yes.
That is their contention.
Yes. Was filed, that it was contested, and a decree was made against that. We filed an appeal saying that one of the property is a self-acquired property. In the appeal that they entered into power. That's all.
For the petitioner submits that in terms of
A compromise decree passed by the First Appellate Court in RA number 69 of 2006. Dated 4th of September 2010. The name of Srimati Munisiddamma, daughter of Munishamappa, was entered in the land revenue records in respect of 37 guntas of land in survey number 110/1 of Veerapura village, Kasaba Hubli, Dodballapur Taluk.
D, E, and F.
Mutation entry was carried out in terms of order passed in MR number 20/2012-13. Stop. Nevertheless, contesting respondents number
With, respondents. With 5-2.
ಅಲ್ಲ ಶ್ರೀನಿವಾಸ್ ಮತ್ತೆ ಲಕ್ಕಣ್ಣ ಇಬ್ರೆ
Srinivas.
contesting response number 5 and 6.
6.
Raised a dispute in the form of an appeal under section 136(2) of the Karnataka Land Revenue Act number 1964 in RA bracket T close 73/2016-17 before the Assistant Commissioner, Dodballapur Subdivision, challenging MR number 20/2012-13. So, Learned Counsel submits that as could be seen from the order of the Assistant Commissioner dated 4/8/2017, it appears that the petitioners were placed ex parte and order was passed by the Assistant Commissioner cancelling the mutation in MR number 20/2012-13, and the Tahsildar was directed to enter the name of the appellants therein. Stop. As soon as the petitioners came to know about the orders passed by the Assistant Commissioner, they approached the Deputy Commissioner and filed revision petition number 120/2017. However, the Deputy Commissioner dismissed the revision petition while noticing that the Assistant Commissioner had remanded the matter back to the Tahsildar, and therefore the revision petitioners would approach the Tahsildar with supporting documents regarding acquisition of title and mutation. So, Learned Counsel submits that the Assistant Commissioner has not remanded the matter back to the Tahsildar. So, it was only stated in the operative portion of the order of the Assistant Commissioner that the matter is sent back to the Tahsildar for entering the name of the appellants there. It is response number 5 and 6 herein. So, Learned Counsel submits that the mutation entry made in MR number 20/2012-13 was in terms of a judgment and decree passed by a competent civil court, and therefore the same could not have been set aside by the revenue authorities. Stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders dated 4/8/2017 passed by the Assistant Commissioner and the order of the Deputy Commissioner dated 27/6/2022, till the next date of hearing.
Emotional, Bharadwaj. 30.
ಅದಕ್ಕೆ ಅವ್ರ ಅದ್ರಲ್ಲಿ Two 2020. Application is made on 2/11/2020. Annexure C. ಅವರು ಸಿಮಿಲರ್ ಆರ್ಡರ್ಸ್ ಒಂದು ಪಾಸ್ ಮಾಡಿದೀವಿ. ಈ ಸುಮಂತ್ ಭಾರದ್ವಾಜ್ ex-servicemen ಚೇಂಜಸ್ ಆಗ್ಬೇಕಷ್ಟೇ. ಅಪ್ಲಿಕೇಶನ್ ಡೇಟೆಡ್ 2/11/2020. There's a direction to consider and pass order. Same order. Then at AGA takes notice for all the respondents.
Yes, please. This is a matter where, my lord, in view of some subsequent development, there was an amendment has been brought in. What has happened, my lord, in terms of annexure L, the petitioner approached this honorable court on the previous occasion, as there was the entry in the RTC has not been mentioned with respect to her land holding. So this honorable court has directed the government authorities to consider the representation and pass appropriate orders. As there was no orders passed within a specified time, we have approached this honorable court, the content proceeding. Thereafter, the government has passed an order, which is subject matter of the amendment, wherein, my lord, they admit to the fact that there was a title document with respect to the allotment of grant in favor of the petitioners are available. But Lord, they also say in the same memorandum that this land has been allotted in favor of respondent of court, as we were not in physical possession, as we were residing in other village. That is the contention which has been mentioned. Lord, I have also challenged with respect to the DC's order, where my land has been taken illegally and been allotted to respondent of court. There was no proceeding initiated, no acquisition proceeding, nor any grant which is
Now you are on IA number 1 of 2022.
Yes, I sought for amendment of these pleadings and also the challenge to the endorsement which is being issued, which is pursuant to annexure A, which is also been impugned before this court. Direct violation of Article 301, which protects my right over the land. I got to see the page 10 of the document which I have annexed, which gives the entire details of this matter.
Endorsement dated 7/3/2022.
Yes, my lord. May I read it? ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧ ಶ್ರೀಮತಿ ಶಾಂತಮ್ಮ ವೆಂಕಟರಾಮ ಸೋ ಅಂಡ್ ಸೋ ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಯಲಹಂಕ ತಾಲೂಕು ಸೋ ಅಂಡ್ ಸೋ
4 ಎಕರೆ ಜಮೀನಲ್ಲಿ 4 ಜನರು 80ರಿಂದ ಹಿಂದಿನಿಂದ ಉಳುಮೆ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಮಂಜೂರಾತಿಗಾಗಿ ತಹಸೀಲ್ದಾರ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋಯನ್ಸೋ. ಅರ್ಜಿದಾರ ಹೆಸರಲ್ಲಿ 4 ಎಕರೆ ಮತ್ತು ಉಳಿಕೆ 4 ಜನರ ಹೆಸರಿಗೆ ಬೇರೆ ಬೇರೆಗೆ ವಿಸ್ತೀರ್ಣವನ್ನು ಮಂಜೂರು ಮಾಡಿರುತ್ತಾರೆ. ಮಂಜೂರಾತಿ ಆದೇಶಂತೆ ಅರ್ಜಿದಾರ ಹೆಸರಿಗೆ RR ನಂಬರ್ 712 ಅಂಡ್ MR ನಂಬರ್ 12 of 9182 ರಂತೆ ಖಾತೆ ಸಹ ದಾಖಲು ಮಾಡಿದ್ದು ಕೈ ಬರ ಪಾಣಿಗಳು ನಮೂದಿಸುತ್ತದೆ. ಸದರಿ ಜಮೀನನ್ನು ರಾಷ್ಟ್ರೋತ್ಥಾನ ವಿದ್ಯಾಸಂಸ್ಥೆ ಮತ್ತು ಇತರೆ ಸಂಸ್ಥೆಗಳಿಗೆ ಮಂಜೂರಾತಿ ಮಾಡುತ್ತಿರುವುದರ ವಿರುದ್ಧ ತಕರಾರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಅರ್ಜಿಯ ಬಗ್ಗೆ ಕ್ರಮ ವಹಿಸದಿರುವುದಿಲ್ಲವೆಂದು ಘನ ಸರ್ಕಾರ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಅರ್ಜಿ ಸೋಯನ್ಸೋರಂತೆ ದಾಖಲೆ ಸಲ್ಲಿಸಿದ್ದು ಘನ ನ್ಯಾಯಾಲಯ ಆದೇಶದಂತೆ 5721 ರಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸುವ ಮನವಿ ಬಗ್ಗೆ 8 ವಾರದೊಳಗಾಗಿ 2ನೇ ಪ್ರತಿವಾದಿಯಾದ ತಹಸೀಲ್ದಾರ್ ಕ್ರಮ ವಹಿಸಲು ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ನಿಮ್ಮ ಮನವಿಯ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಜಾಲಹುಬ್ಳಿ ಬೈಯಪ್ಪನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 80 ಮೂಲತಃ ಸರ್ಕಾರಿ ಗೋಮಳದ ಜಮೀನಾಗಿದ್ದು ಸದರಿ ಜಮೀನಲ್ಲಿ ಶ್ರೀಮತಿ ಶಾಂತಮ್ಮ ಮತ್ತು ಇತರೆ 3 ಜನರಿಗೆ ಮಂಜೂರಾದ ಬಗ್ಗೆ ಅಧಿಕೃತ ಜ್ಞಾಪನ ಆದೇಶ ಮತ್ತು ಇನ್ನಿತರೆ ದಾಖಲೆಗಳು ಲಭ್ಯವಿರುತ್ತದೆ. ಆದರೆ ಸದರಿ ಕಡಿತದಲ್ಲಿ ನಡೆಸಿರುವ ಮಹಾಜನಂತೆ ಸದರಿ ಜಮೀನಲ್ಲಿ ನೀವು ಸ್ವಾಧೀನದಲ್ಲಿರುವುದಿಲ್ಲವೆಂದು ಮತ್ತು ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿದು ಬಂದಿದ್ದು ನೀವು ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿರುವ ಮನವಿಯನ್ನು ತಾವು ಸ್ವಾಧೀನದಲ್ಲಿರುವುದರಿಂದ ರಾಷ್ಟ್ರೋತ್ಥಾನ ವಿದ್ಯಾಸಂಸ್ಥೆ ಮತ್ತು ಇತರೆ ಸಂಸ್ಥೆಗಳಿಗೆ ಮಂಜೂರು ಮಾಡಬಾರದೆಂದು ಕೋರಿರುತ್ತೀರಿ. ಸದರಿ ಜಮೀನನ್ನು ಸರ್ಕಾರದಿಂದ ರಾಷ್ಟ್ರೋತ್ಥಾನ ಮತ್ತು ಇತರೆ ಸಂಸ್ಥೆಗಳಿಗೆ ಮಂಜೂರು ಮಾಡಿರುವುದಿಲ್ಲ. ಈ ಜಮೀನನ್ನು ಯಾರೂ ಉಳುಮೆ ಮಾಡದ ಕಾರಣ ಕೆಲವರು ಅನಧಿಕೃತ ಒತ್ತುವರಿ ಮಾಡಿರುವುದನ್ನು ತೆರವುಗೊಳಿಸಿ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಯನ್ಸೋರಂತೆ ವಸತಿಹೀನ ರೈತರಿಗೆ ಆಶ್ರಯ ಯೋಜನೆಯಡಿ ಮನೆಗಳನ್ನು ನಿರ್ಮಿಸಿಕೊಳ್ಳಲು ಸರ್ಕಾರದ ಅಂಗಸಂಸ್ಥೆಯಾದ ರಾಜೀವ್ ಗಾಂಧಿ ವಸತಿ ನಿಗಮಕ್ಕೆ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಲಾಗಿದೆ. This is a direct violation of Article 301. They also admit the fact that I am the owner of this land, which is been granted in my favor. I have also produced all the records which clearly depicts that I am the owner of this land. Just because
what is the prayer in this petition?
My lord, annexure A and B, wherein my lord this particular land has been allotted in favor of respondent number 4, has been challenged.
So, which means for what purpose are you now challenging this one? Anyway, you have already challenged the order granting this land in favor of Rajiv Gandhi Corporation.
Earlier round of litigation, where with respect to non-entry in the RTC, with respect to my name, has been challenged.
The order dated 17/12/2021.
Yes, that is at annexure L. 5th July 2021. Annexure A is at page 32. Seventeenth 2021, where my lord, if my lords come to ಭಾಗ 1 ಸರ್ಕಾರಿ ಗೋಮಾಳ ಭೂಮಿಗಳ ವಿವರ ಕ್ರಮ ಸಂಖ್ಯೆ 3, this is the land which they are referring to as it is ಸರ್ಕಾರಿ ಗೋಮಾಳ ಭೂಮಿ. In fact, in their endorsement,
this is the order that is referred in the endorsement.
Yes, this order
I have already challenged.
Yes, already challenged.
Then,
in addition,
for what purpose do you want to again bring that endorsement? Not necessary. You have already challenged the order.
I've already challenged, but in addition to that, they should not be any order which is against us. I need to bring it to my lord's notice.
Sir, the order on the basis of which the grant is made in favor of the corporation,
yes,
you have already challenged in the writ petition. Now, why do you want to bring in that endorsement? For what purpose? Not necessary. That we will consider along with the main matter.
I will be grateful.
There is a stay.
Yes.
But what more is there to be considered in this writ petition? See, if you admit that land has been granted in their favor and their names were in the land revenue record, without cancellation of the grant, where is the question of granting it to the corporation? Allama, the order annexure A is already under challenge. ಇದು ಹೇಳ್ಬೇಕಾಗಿತ್ತಲ್ಲ ಅವರು. Endorsement alla, even in the order at annexure A, they have not said so. It is proceeded on the ground that it is a Sarkari Gomala ಮತ್ತು Sarkari Karab. You will not have any say in this matter. ಏನು objection file ಮಾಡ್ತೀರಾ ನೀವು? The challenge is raised against the action of the government. You can succeed only if it is found that the land did not belong to them. It was a government land which was available to be granted to you. Literally, I don't think you have any say in this matter at all. Huh?
So then there is no work. There is no civil work also.
Photographs, we saw that they were just putting up
Yes,
the compound wall.
fencing, that is with respect to the neighboring lands. Which
Compound.
also,
That nothing more.
there was not much money has been spent. At the earliest, my lord, I'll come before this court.
Huh? We are concerned only with their property. When once it is stated by your own officer that yes, there is records to substantiate their contention that it was granted in favor of so and so person, and their his name was entered in the land revenue records.
And also, my lord, the official memorandum, there were other people who were granted along with me. Their land, my lord, there was an RTC which is running. And my lord, the respondent, that is the DC's office, conveniently ignore that mentions that there is those land they want to proceed further, and only they take my land, where my name in the RTC is not mentioned, only on that ground.
Contention is that by virtue of the impugned order dated 17/12/2021 at annexure A, passed by the Deputy Commissioner, Bangalore Urban District, ನಿಮ್ದು ಇದು ಭಾಗ 1ರಲ್ಲಿ ಬರ್ತಾ ಭಾಗ 2ರಲ್ಲಿ
ಭಾಗ 1ರಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 3,
an extent of 39 acres and 22 guntas of land including ಯಾವುದು
ಕ್ರಮ ಸಂಖ್ಯೆ 3,
including
ಯಲಹಂಕ, ಜಾಲ ಹೋಬಳಿ, ಬೈಯಪ್ಪನಹಳ್ಳಿ, ಸರ್ವೆ 3 acres 20 guntas.
ಅದೇ ಗೊತ್ತಾಯ್ತು. including 3 acres 20 guntas of land in survey number 80 of ಬೈಯಪ್ಪನಹಳ್ಳಿ, ಜಾಲ ಹೋಬಳಿ, ಯಲಹಂಕ ತಾಲೂಕ್ sought to be was granted in favor of the fourth respondent, Rajiv Gandhi Housing Corporation Limited, for construction of multi-storied residential building. Although the land in question belongs to the petitioner, and the Deputy Commissioner had no manner of right, no manner of power to grant the land in favor of the respondent corporation. Stop. In this regard, attention of this court is also drawn to the endorsement dated 7/3/2022 at annexure R filed along with IA number 1 of 2022 to substantiate the contention of the petitioner that 4 acres of land each were granted to various persons, including the petitioner here.
There is a handwritten RTC also in favor of the petitioner along with the MR.
In the year 1981-82. And the name of the petitioner was entered in the land revenue records in terms of MR number 12 for 1981-82. So, next para. At the request of the learned AGA, released this matter on 18th of August 2022. August. 23rd of August.
Interim order may be extended.
Interim order granted earlier stands extended to the next date of year.
Petitioner. 17 and 8 we have Karnataka land.
When was the order passed by the State Commissioner? (2016). Learned AGA takes notice, HCGP takes notice for both the respondent. Same as 3271 of 2022. Go before the Assistant Commissioner. The reach time is granted for complaints of office objections.
34. I'm informed that all the office objections have been complied with. I think.
There are initially 5 office objections were raised. Subsequently, 2 more are raised, and none of them are complied with. This is the latest information.
The file was not traceable. The acknowledgement is here. It is served on 26/7. Unlike here, what has happened is Deputy Commissioner, in spite of the directions of this one, is saying it is converted land and it falls within BBMP limits. Revenue entries are changed without notice to the petitioner's husband, who was then alive. And then this one before writ petition. Whether you submit or not submitting. Please. What happens is, by virtue of these revenue entries, parties transfer the property. Here, the civil matter is pending. Without notice, the revenue entries are changed. Kindly see the order at page 231. Kindly see the order of this court at page 231. (233) is the order, and the Deputy Commissioner's noting also, he says this order is produced, there is no reference at all to the High Court order. And he also says land is converted, land is within BBMP limits. They don't have jurisdiction at all, they change the revenue entries without notice. It is converted land. This honorable court says at page 237, a perusal of this.
You have not been served with a copy. Huh?
Postal acknowledgement, their sites.
ಆಮೇಲೆ ನಾನು RPD ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ ಫೈಲ್ ಸಿಗಿಲ್ಲ
The lady is 88 years old. Already her husband passed away.
Sari, ಆಯ್ತು. Who has filed the suit? Filed the suit.
We had filed the suit. Encroachment. Now an RFA is pending in respect of that. The city civil
Suit for
removing the encroachment.
only permanent injunction or mandatory injunction.
Mandatory injunction, removing the encroachment. What happens is
Against
the city civil court proceeds on the premise because the DC earlier said it will be the revenue appellate tribunal if the order was challenged. The Karnataka revenue appellate tribunal said it will be subject to the jurisdiction of the civil court. Civil court says you have not challenged that KT order, so this suit is dismissed. Now RFA is pending. Now in the meanwhile, this on court held that we had not brought it to the notice in the writ petition that the land was converted, it fell within BBMP limits. The division bench judgment of this one court, there is no jurisdiction, the revenue authorities. That the DC notes in his order, that order is produced of the High Court. If the land is converted, they have given material to show land is converted, it falls within BBMP limits right from 2007. Still, he dismisses the appeal filed by us. Both the authorities, AC and DC. So status quo ante has to be done with 17.
You challenge the order of the assistant commissioner, is it?
We challenge the order of the assistant commissioner.
What was the order of the assistant commissioner? Who approached the assistant commissioner?
This one court had directed the Tahsildar to do a survey and then submit a report. What happens is all these revenue authorities, they don't even intimate us. A report was filed, no copy was given to us, date was given. We challenged it before the assistant commissioner. Then the assistant commissioner also, no date is given. Only when they file a caveat, we come to know that an order has been passed.
What did you challenge before the assistant commissioner?
That you, Lordship, may see the order of justice. The order of the before the deputy commissioner is at page 55. Division petition order.
No. Which is the order of the assistant commissioner?
Assistant commissioner's order at page (181). Because under the Land Revenue Act, before the mutations are changed, a notice will have to be given. No notice, just based on his representation, they change the revenue entries after the suit is dismissed.
Rectify the entries in respect of so and so and restore the position prior to 2017-18. Pending disposal. RFA.
Both the authorities would say once the civil proceedings, if you succeed, then it will be changed. They couldn't have changed it in 2017. They have no inherent jurisdiction. Because the apex court would say when their inherent jurisdiction itself is not there. Kindly see the memo dated 1907. We have produced the order sheet of the DC. The reasoning given by the deputy commissioner is that these revenue entries were changed before the order of the High Court.
Your revision petition is dismissed.
Yes.
And what did the assistant commissioner do?
Beg your pardon.
What did the assistant commissioner do?
Assistant commissioner, same thing. You, after the civil suit is disposed of,
Ah.
you can get the revenue entries.
Sorry, no. What is the interim relief that you're asking for now?
We are now saying that
To stay the operation of MR number T2 2017-18.
Yes, correct.
At this stage, it is not possible, sir.
Allah, what happens? When a person
Learned
has no
AGA.
inherent jurisdiction.
Learned AGA takes notice for response number 1 to 3. Learned counsel Shrikant S has entered appearance for response number 4 by filing a caveat petition. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. Full stop. 2 weeks are granted to the learned counsel for response number 4 to file statement of objections. Learned counsel for the petitioner is requested to serve one more copy of the petition on learned counsel for response number 4. Release this matter on 25th of August 2022. It did not be a big written statement of objection, a short one. Yes. Keeping open the office objections and the starting a level.
Hearing for petition. Petition has been served on AJ on the same day.
Please give a copy.
ಕೊಡ್ತೀನಿ ಮತ್ತೆ ಅವತ್ತೇ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಎರಡು ಸೆಟ್ಟೆ ಕೊಡ್ತೀನಿ ಅವತ್ತು
All right.
Connection E money. Construction made in the land comes in the Ramtana of the village.
No, last time we had directed that this is not the only building there. They are trying to evict this person on the ground that he had not got the conversion of the land from agricultural to non-agricultural purpose. That there is a road formed and this is one of the houses there. So I directed you to secure instructions from the Tahsildar. One copy kodi avrige.
Please.
Alligo kodo badlu dayaviಟ್ಟು ಅವರು ಕೊಡಿ. Yes. At the request of the learned AGA, released this matter on 18th of August 2022. Interim order granted earlier stands extended to the next date.
Respondent number 4 ಗೆ notice ತಗೊಂಡಿದ್ದೀನಿ. ಅದ್ರ ಮೇಲೆನೆ ಅವ್ರು ಸೀಲ್ ಹಾಕ್ಬಿಟ್ರು.
Is a copy idea nama? Learned AGA submits that she has received copies of the writ petition.
ಇದ್ರಲ್ಲೇ challenge respondent number 2 entries. Adverse notice. Adverse notice 25/7/2022 ಗೆ adverse ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು notice issue ಮಾಡಿದ್ರು. ಅದನ್ನೇ challenge. Because I have referred a declaration suit before the trial court in Kolar, which is pending for consideration. Will respondent number 4 ಏನ್ ಮಾಡ್ತಾರೆ? They came and tried to dispose me from the property. Avaga I have filed a suit.
Who is appearing for respondent number 4? Carried out.
ಅದನ್ನೇ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿ ನಾನು ಫೈಲ್ಡ್ ರಿಪಿಟಿಷನ್ ಬಿಫೋರ್ ದಟ್ ಓನ್ಲಿ. ಅದನ್ನೇ ಅಲ್ಲೆಲ್ಲ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ. ಇದರಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ನೇ ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಪೇಜ್ ನಂಬರ್ 29.
ಏನು ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್?
ಇದರಲ್ಲಿ ಡಿಡಿಎಲ್ಆರ್ ಅಲ್ಲಿ ಡಿಡಿಎಲ್ಆರ್
ಅದು ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏನಾಗಿದೆ ಇದರಲ್ಲಿ? ಹಾ ಹೇಳಿ. In survey number 189/2B.
Earlier 189/2 it was there.
But they gave us the representation. They say that because it can't be demarcated, we move the content. Content the regulator tells us after getting a demarcation, the whole protection should be provided. Then we move the repetition there and order for survey of the
It was fast.
Based on that order, survey was done. Adverse was not. The application on the initial application was in 2020, one was given after application. 4/11/2021 my application for adverse. After survey. Based on that and adverse now they don't want kindly see the conduct. They don't want this adverse this litigation has to be over. Even if it succeeds, whatever no dispute, I am the one of the and they are 90.22 and whatever he claims, at the same time, more land is there. Kindly come to what I have done.
Yes. You are the owner of which land?
Component property, 189/2B1. 189/2B1. It has 27 gunters were there. Now for me, 189/26 was made. That's okay. That given. That is for the same extent, 4 acres 90.12 gunters. The remaining extent is also from 4 acres 8 gunters is remaining. He claims 4 acres is only the one.
There was a counter complaint was also given and Nammela counter case has been filed.
ಸರಿ ರೀ, ಇವಾಗ
ಅಲ್ಲ ನಾನು I have filed a suit.
ಅದನ್ನು ನೋಡಿ ಸ್ವಲ್ಪ
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ನಾನು 20 ವರ್ಷದ ಮಾವಿನ ಗಿಡ ಎಲ್ಲ ಹಾಕಿದ್ದೆ. ಕೋವಿಡ್ ಟೈಮ್ ಅಲ್ಲಿ in the year 2020
ಇವಾಗ ಏನಾಗಿದೆ? ವಾಟ್ ಇಸ್ ದಿ ಪ್ರಾಬ್ಲಮ್?
ನಾವು ವಿ ಆರ್ ಇನ್ ದಿ ಪೊಸಿಷನ್ ಹಿಂಗ್ ಸ್ಟ್ರೈಟ್ ಆಗಿತ್ತು ನಮ್ದು. ಹಿಂಗ್ ಸ್ಟ್ರೈಟ್ ಆಗಿತ್ತು ಇದು 181 4 ಎಕರ್ಸ್ ಇದ್ದಿದ್ದು. ಇವ್ರು ಇವಾಗ ಹಿಂಗ್ ತಳ್ಬಿಟ್ಟು ಮೇಲಕ್ಕೆ ತಳ್ಳಿದಾರೆ. ನಮ್ಮ ಮೇಲಕ್ಕೆ ತಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. ದೇವರ್ ಅವರು ಮೇಲೆಗಡೆ ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ತಾ ಇದ್ರು. ಹೌದು, ಕೆಳಗಡೆ ಇತ್ತು ಪೀಸು, ಮೇಲೆ ಇತ್ತು, ಸೆಂಟ್ರಲ್ ನಾವಿದ್ವಿ. ಸೊ ಇವಾಗ ಇವ್ರೇನ್ ಮಾಡಿದ್ರು, ಅದ್ಬಸ್ ಇದು ಪೋಡಿ ಮಾಡಿಸ್ಬಿಟ್ಟು ನಮ್ಮನ್ನ ಮೇಲಕ್ಕೆ ತಳ್ಳಿದ್ರು. ಸೊ ಇವ್ರು ಯಾವಾಗ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಬರ್ತಾ ಇತ್ತು, ನಾವು ಯಾವ ಫೈಲ್ಡ್ ಸೂಟ್ ಫಾರ್ ಇಂಜೆಕ್ಷನ್ ದೇರ್ ಆಫ್ಟರ್ವರ್ಡ್ಸ್ ಅದು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಯಾವ ಫೈಲ್ಡ್ ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್. ಅಲ್ಲಿ ಚೆಕ್ ಬಂದು ಅನ್ಸರ್ಟೈನ್, ನಮಗೂ ಅನ್ಸರ್ಟೈನ್, ಅವ್ರಿಗೂ ಅನ್ಸರ್ಟೈನ್. ಓನ್ಲಿ ಆನ್ ದ ಪೊಸಿಷನ್ ಬೇಸಿಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಇದು ಪೊಸಿಷನ್ ನ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು. ನಮ್ಮ ಮಾವಿನ ಗಿಡನ ರಾತ್ರಿ ಕಡಿತಾರೆ, ಕಾಂಪೌಂಡ್ ವಾಲ್ ನ ಹೊಡೆದಾಕ್ತಾರೆ. ಫೋಟೋಗ್ರಾಫ್ಸ್ ಎಲ್ಲ ಇದೆ ಸರ್. ಪ್ರೊಡ್ಯೂಸ್ ದಿಸ್ ಅಂಡ್ ಬಿಫೋರ್ ದಿಸ್. ಅದನ್ನ DDLR ಯುವರ್ ಆನರ್ ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಟು ದ ಪೇಜ್ ನಂಬರ್ 29. DDLR ಆರ್ಡರ್ ಅಲ್ಲಿ ಇಟ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Do you mean to say that ಇಲ್ಲಿ ಗ್ಯಾಪ್ ಬಂದಿದೆಯಲ್ಲ?
ಹೌದು ಸ್ವಾಮಿ, ಇದನ್ನ ನನ್ನ ಮೇಲೆ ತಳ್ಬಿಟ್ಟು ಇನ್ ಮೇಲೆ
ಆ ಗ್ಯಾಪ್,
ಈ ಗ್ಯಾಪ್ ಹಿಂಗ್ ಸ್ಟ್ರೈಟ್ ಇತ್ತು ನಮ್ದು ಉದ್ದಕ್ಕೆ ಪೋರ್ಷನ್. ಕೆಳಗಡೆ ಇವರಿದ್ರು
ಅಬಟಿಂಗ್ ದಿ ರೋಡ್,
ಅಬಟಿಂಗ್ ದಿ ರೋಡ್ ಇವರಿದ್ರು. ಇಲ್ಲಿ 1 ಎಕರೆ ಇವರೇ ಯಾರಿಗೋ ಜಯರಾಜ್ ಅನ್ನೋರ್ಗೆ ಮಾರಿದಾರೆ. ನಾನು ಇಲ್ಲಿ ಮೇಲೆ ಇದೀನಲ್ಲ, ಸ್ವಲ್ಪ ಮೇಲೆ ತಳ್ಳಿದಾರಲ್ಲ,
ಇಲ್ಲಿ ಸ್ಟ್ರೈಟ್ ಆಗಿ ಹಿಂಗೆ ಉದಾ ಇದೆ ನನ್ನ ಪೀಸ್. ಉದಾ ಇತ್ತು ಪೀಸ್.
How can it be done in the absence of this person? This fixing of the adbasta, it should be after giving notice to the neighbor. Can it be done unilaterally?
ಅಲ್ಲಲ್ಲ, no, Your Honor, this has been ಆಫೀಸ್ ಅಲ್ಲಿ ಬಂದ್ ಮಾಡಿರೋದು. ಅಲ್ಲಿ ಫಿಸಿಕಲ್ ಅಲ್ಲಿ ಬಂದೇ ಇಲ್ಲ. ಫಿಸಿಕಲ್ ಆಗಿ ಬಂದಿಲ್ಲ. Your Honor, may kindly turn to the page number, in page number 28. ಅದ್ರಲ್ಲಿ DDLR specific ಆಗಿ ಆರ್ಡರ್ ಹೇಳಿದ್ದಾರೆ.
ಆಯ್ತು,
ಸಿವಿಲ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
Now that they have given you a copy of this
Please.
adbasta,
ಹೌದು.
whatever application you want to file, you please file. If you want to challenge this also, please file an application to bring it on record, and you challenge this also.
Please. ಇದರಲ್ಲಿ
Learned
kindly my lord, page
counsel
number.
for respondent number 4 has filed a memo dated 11/8/2022 along with a copy of the adbast sketch prepared by Sildar. Kolar Taluk. A copy of the same is also handed over to the learned counsel for petitioner. Stop. Next para. Learned counsel for the petitioner seeks for a short accommodation to file necessary application in respect of the adbast sketch prepared and filed along with the memo dated 11/8/2022. Full stop. A week time is granted to do the needful.
Entry ಮಾಡೋಣ.
Entry ಮಾಡಿ ಏನ್ entry ಮಾಡಿ?
ಅಲ್ಲಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ, ನಾವು ಇವಾಗ ಈ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೀವಿ. ಆಲ್ರೆಡಿ ಇವ್ರ ಮುಂಚೆ ಏನಾಯ್ತು, ಗಲಾಟೆ ಎಲ್ಲ ಆಗ್ಬಿಟ್ಟು ನನ್ನ ಸೈಡ್ ಅಲ್ಲ, ಹಂಗ ಇರೋವಾಗ ಸ್ಟೇಟಸ್ ಡಿಕ್ಲರೇಷನ್ ಶೂಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಾದ್ರೆ
Don't do anything. Please await the orders. Don't go just because there is an adbast made now. Don't go on insisting there that no, possession should be given in terms of this. Athara ಏನು ಮಾಡಕ್ ಹೋಗ್ಬಿಡಿ ದಯವಿಟ್ಟು. Please wait, sir. Parties are directed to maintain status quo as on today without as on today. Full stop. Yes.
Application. Number 32 Arjun, number 38, page number 10.
Appearing for the petitioners.
A reason for rejecting the application filed at the hands of the petitioner seeking conversion of the land. ಅದೇ at the request of learned HCGP released this matter on 17th of August 2022 to enable the learned HCGP to secure information from the second respondent Deputy Commissioner Mandya district as to the reasons for rejecting the application filed by the petitioner seeking conversion of lands.
The acquisition is of the 1999, my lord. In the previous round of litigation, I have filed writ petition. In that writ petition, the preliminary notification was passed. They have not issued any final notification. No award is passed. No possession was also taken, my lord. And after this, I have filed my conversion application. Now they have rejected my.
That is why I am asking. Let him at least get the information. If they say no, it was rejected without proper reasons, then we will set aside this order and we will direct him to reconsider your application.
59. Adappa 8.
I appear for respondents 4 to 6 minutes.
Waiting instructions from time. Just 2 weeks time.
ಏನಕ್ಕೆ?
Instruction from time.
ಹಾ? ಏನ?
Photos and documents. Client
ಹಾ?
Photos and documents. Petitioners.
Who has filed this IA1 for direction? ನೀವೇನೆ? ಹಾ? At the request of learned counsel for petitioner, release this matter next week.
Petitioner, this is the writ of madam is last date of occasion also. Government will take instruction last 2-3 days.
Nagara Taluk as to why the names of the petitioner are not entered in the land revenue records consequent to the Sagoli chits granted in their favor, as seen at annexures D and D1. Huh?
With land.
You will direct them to Ibro separate ಇದೇನು ಒಂದೇ
Separate.
ಹಾ
Separate.
ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಒಂದೇ ಹೆಸರು ಬರೀತಿರಲ್ರಿ ಹಾ ಪಿ ವಾಸುದೇವ ಸನ್ ಆಫ್ ಪುಟ್ಟ ನಾಯಕ ಒಂದೇ ಬರೆದಿರೋದು ನೀವು ಎಲ್ಲಿದೆ ಈಗ ಅವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ
Actually, B1 page number 20. Page number 22. G.R. Ishwaram. In Ramana.
Why have you not stated in the petition then?
Petition also mentioned.
Synopsis ತೆಗಿರಿ ನಿಮ್ದು ಬರೀ ಜಿಪಿ ವಾಸುದೇವನೇ ಬರ್ದಿದ್ದೀರ ಅಷ್ಟೇ
Three facts ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ.
ಹಾ
3 facts ಅಲ್ಲಿ ಹೇಳಿ. Page number 2 ದಲ್ಲಿ.
It is the contention of the petitioners that pursuant to the orders passed by the Committee for Regularization of Unauthorized Occupation on 13/10/1998, the lands in respect of which applications were filed at the hands of the petitioners herein, comma, grants were directed to be made by the committee. Stop. Consequent to the said resolution of the committee, digits were also issued in favor of the petitioners. Stop. However, till date, the names of the petitioners have not been entered in the land revenue records. And on the contrary, notices are sought to be issued at the hands of the respondent Tahsildar, Hosanagara, calling upon the petitioners to vacate from the land in question, stating that they were in unauthorized occupation. Stop. Prayer in this petition is to direct the respondent authorities to consider the representations given by the petitioners to effect entry of their names in the land revenue records pursuant to the grant orders and Sagoli chits issued in their favor. Stop. Next para. Having regard to the prayer made in the writ petition and the contentions raised by the petitioners, this court is of the considered opinion that the respondent Tahsildar is required to consider the representations given by the petitioners. The Tahsildar is required to ascertain from the original register as to whether such a resolution was passed by the Committee for Regularization of Unauthorized Occupation. And if so, whether Sagoli chits were in fact granted in favor of the petitioners. So, if it is found that no such resolution was passed by the committee or no such resolution was passed by the committee, then the Tahsildar is required to place the applications of the petitioners before the Committee for Regularization. Stop. The committee shall consider the applications filed by the petitioners after affording an opportunity of hearing to the petitioners and causing an inquiry, and thereafter pass necessary orders as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order. Stop. Next para. On the contrary, if it is found that such a resolution has indeed been passed by the committee, then Sagoli chits are required to be issued in favor of the petitioners. Full stop. Sagoli chits are also issued, then the names of the petitioners are required to be entered in the land revenue records. Stop. Next para. The respondent Tahsildar shall follow the directions given by this court and act accordingly. Stop. If it is found that grants were indeed made in favor of the petitioners and Sagoli chits were issued, then the names of the petitioners shall be entered in the land revenue records as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order, ordered accordingly.
Appellate for the respondent 4 to 11, my lord.
Number 41.
I pray for 1 week time, my lord. Senior is not taking.
That may be taken upon benefit because in order to 50 years, my lord, in cancelling the petition. Petition order is of 1960-61. Cancelled on 28/4/2016.
Yes, this matter was listed on today at
Yes,
your
madam.
request.
Yes, my lord. Senior is not keeping well today, my lord. Kindly have it on Wednesday.
ಏನ್ರಿ ಇದು ಹಿಂಗ್ ಮಾಡ್ತೀರಾ ನೀವು?
Because my lord,
Huh?
today is unwell. That is the reason, my lord.
Third time the same. Sorry. Bring the word to the.
Every time this is what is been happening in
No,
respect of your case.
No, my lord. In the last date, we sought time for filing the objections, but it has been posted for final hearing today.
No. We are taught at the request of learned counsel for the contesting respondents, release this matter on 11/8.
Yes, my lord. But the senior is unwell today because of that reason, my lord.
Next week ಹಂಗೆ ಹೇಳ್ತೀರಾ?
ಇಲ್ಲ, we will be ready, my lord, on Wednesday.
The lordship may kindly take this matter as a big heard because this repeatedly, I don't think there is any genuineness in this.
So,
in this case.
this matter was directed to be listed today at the instance of the learned counsel for the contesting respondents. Come on, nevertheless, learned counsel submits that the counsel on record is unwell and therefore seeks for adjournment. Full stop. Learned senior counsel Shri P.P. Hegde, appearing for the petitioners, would submit that on more than one occasion, this matter has been adjourned at the instance of the contesting respondent. Stop. Next para. Release this matter on 18th of August 2022. Stop. Made clear that the matter shall be heard and disposed of on the next date of hearing, irrespective of whether the learned counsel for the contesting respondents is prepared to address his argument or not. Full stop. Yes.
I request to take up 2:30 minutes. The board time. Please.
2:30.
Most good. Yeah. Not find this Ayyappa.
HR Vishwanath. ಯಾವ್ದ್ರಿ ಇದು? 6358 538
ಪಾಯಿಂಟ್ ಗಲತ್ ಹಾಕಿದ್ದಾರೆ ಹೆಸರು ತೋರಿಸಿಲ್ಲ.
ಇಲ್ಲ, ಈ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ದನು ಇದಕ್ಕೆ ಹಾಕ್ತಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ದ 6538 ಇದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್.
6358
ಅಲ್ಲ 65 ಏನ್ರಿ ನೋಡ್ರಿ ಯಾವ್ದ್ರಿ ಯಾವ್ದ ತೆಗ್ದು ಇದಕ್ಕೆ ಹಾಕ್ಬಿಟ್ಟಿದ. ಕಲ್ದಾಕ್ರಿ ಹೇಳ್ಬಿಟ್ರ ಅವ್ರ ಏನ್ ಮಾಡ್ತಾರ? ಏನಾಗಬೇಕಿದೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಆರ್ ಗ್ರಾಂಟೆಡ್.
ಎಂಟ್ರಿ ಮಾಡಲ್ is granted.
If matter can be disposed of, you can make submission.
Please.
What is the matter?
That the land in question was granted in favor of the petitioner's father, Mellor. On 12/4/1951. In the land bearing survey number 11, block number 7. And his name was entered in the records, and thereafter Mellor one Narsappa, son of Limishetipura Narsappa, has sold his land by registered sale deed dated 7/6/1974 in favor of respondent number 4 and 5. 5 and 6. Then Mellor, however, pursuant to the sale deed dated 7/6/1974, no mutation entries have been taken place. However, Mellor, thereafter respondent number 4 has purchased 4 guntas of land from 5 and 6 by registered sale deed dated 26/7/2005.
my lord, after the respondent four has purchased the land, my lord, the mutation entries have been made pursuant to that same date, my lord, in the year 2005, showing that, my lord, as if the petitioner has sold the land. Rosh may kindly turn to manager. G, my lord. Here, my lord, the survey number 11 per P5. Shown as Adappa Uruf Narsappa bin Narsappa has sold.
So you approach the assistant commissioner.
I approached the assistant.
Let us see the order of the assistant commissioner.
Assistant commissioner, my lord, there the matter has been ended up in compromise, my lord. The 4 and 5 and 4 by 6 and have also consented for the setting aside the mutation. Thereafter, my lord, respondent number 4 herself has prepared an appeal before the deputy commissioner. During the pendency of the appeal.
Chikagangappa, Sonnappa, Shantamma were the respondents.
Please.
Before the assistant commissioner.
Assistant.
Shantamma, Sonnappa. These are response number 4, 5 and 6.
Please. And
they were
represented by advocate and even the advocate has also signed. Adadmele matte it has ended up in compromise and they have agreed to set aside the mutation entry.
Please read it, sir.
Manager K, my lord.
Page number 48.
48.
Page number 48.
Operative portion, right?
Allah, operative portion ಕಿನ್ನ ಸ್ವಲ್ಪ ಮೇಲೆ
1, 2, 3ನೇ ಪ್ರತಿವಾದಿಗಳಿಗೆ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿರುತ್ತದೆ. 1, 2, 3ನೇ ಪ್ರತಿವಾದಿಯವರು ದಿನಾಂಕ 18/12/2013 ತಮ್ಮ ವಕೀಲರ ಮೂಲಕ ವಕಾಲತನ್ನು ಸಲ್ಲಿಸಿಕೊಂಡಿರುತ್ತಾರೆ ಹಾಗೂ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಯವರು ಮಾಡಿಕೊಂಡಿರುವ ರಾಜಿ ಪತ್ರವನ್ನು ಸಹ ನೀಡಿರುತ್ತಾರೆ. ಗುಡಿಬಂಡೆ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಮರವೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11/P5 ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ ಜಮೀನಿನಲ್ಲಿ 1 ಮತ್ತು 2ನೇ ಪ್ರತಿವಾದಿಯವರು ತಾಯಿಯವರಾದ ಗಂಗಮ್ಮನವರಿಗೆ ಅವರ ಹೆಸರಿಗೆ 36 ಗುಂಟೆ ಮತ್ತು 3ನೇ ಪ್ರತಿವಾದಿ ಶಾಂತಮ್ಮನವರ ಹೆಸರಿಗೆ 4 ಗುಂಟೆ ಜಮೀನುಗಳು MR ನಂಬರ್ 1/2005 6ರಂತೆ ಮತ್ತು MR ನಂಬರ್ 5/2004 5ರಂತೆ ಖಾತಾ ಬದಲಾವಣೆಯಾಗಿರುವುದು ತಪ್ಪಾಗಿ ನಂಬುದಾಗಿರುತ್ತದೆ ಅಂತಲೂ ಸದರಿ ಸ್ವತ್ತುಗಳಲ್ಲಿ ವಾದಿಯವರ ತಂದೆ ಆದಪ್ಪ ಬಿ ಲಿಂಗಶೆಟ್ಟಿಪುರ ನರಸಪ್ಪನವರೇ ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತಾರೆಂತಲೂ ವಾದಿಯವರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ತಮ್ಮಿಂದ ಯಾವುದೇ ತಂಟೆ ತಕರಾರು ಇರುವುದಿಲ್ಲವೆಂತಲೂ ತಿಳಿಸುತ್ತಾ ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ರಾಜಿ ಪತ್ರದಂತೆ ವಾದಿಯವರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ತಿಳಿಸಿರುತ್ತಾರೆ. ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು
what happened before the deputy commissioner?
Before the deputy commissioner, they have disputed the compromise petition. Correct. Now the deputy commissioner has set aside the order passed by the assistant commissioner and directed to restore the name mutation entries which are in the name of respondents 4 to 6. My humble submission is, my lord, your lordship may kindly see, my lord, during the pendency of the appeal before the deputy commissioner, my lord, he has directed the survey, Taluka surveyor, to conduct a survey and to ascertain who is in position of the.
Where is the question of conducting survey, sir? This is a question only regarding entry in the land records.
Please.
Yes.
My lord, you can advise, my lord, may I make this submission, my lord? Your lordship may kindly see, my lord, the sale deed, my lord.
If you want, you go back before the assistant commissioner. We will permit you to go back before the assistant commissioner. Let notice be issued to the other side. If they want to contest the matter, let them contest the matter.
Please, my lord. Till then, my lord, let the entries be.
No, sir.
No, because, my lord,
No. It will be as before the order of the assistant commissioner was passed.
For this reason, my lord. Even your lordship may kindly see, my lord, unanswered chief, my lord, for a moment.
Sir.
For a moment, my lord. For my satisfaction.
Paradilla, sir.
For my satisfaction,
No.
I'll make this submission, my lord.
Yes.
For a moment, your lordship may kindly see unanswered chief, page 41. My lord,
Here, my lord, on the right hand side, column, after Sanke Indur Embathedu, Dinanka 7/6/1974. The sale deed is dated 7/6/1974.
You know, page number 41.
41.
Annexure G.
G. ಇಲ್ಲಿ ಮೂಲ ಸಬ್ ರಿಜಿಸ್ಟರ್ ನೋಂದಣಿ ಬದಲಾವಣೆ ರೀತಿ ರೈಟ್ ರೀತಿ ತಿಳುವಳಿಕೆ ಚೀಟಿ ಸ್ವಾಧೀನತೆ ರೀತಿ ಕ್ರಯ ಸಂಖ್ಯೆ 282 ದಿನಾಂಕ 7/6/1974. Then melod left hand bottom melod ಮೊಕಾಮು ಗುಡಿಬಂಡೆ ಮುಟೇಶನ್ ಆದೇಶ ದಿನಾಂಕ 26/7/2005. In respect of the sale deed dated in the year 1974, melod mutation entry has been directed to be entered in the year 2005, that too without notice to me, and showing that melod even the sale deed is executed by Narsappa, son of Lingashetpura Narsappa. Here, melod, it is shown as Adappa Uruf Narsappa has executed the sale deed.
Where is that sale deed?
Sale deed, melod, I have produced melod. Typed copy at Annexure E, page 31. Page 31. ಗುಡಿಬಂಡೆ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಹಂಸಂದ್ರ ಗ್ರಾಮದಲ್ಲಿರುವ ಆದಿ ಕರ್ನಾಟಕ ತೆಲುಗು ಭಾಷೆ ದಂಡಪ್ಪನ ಹೆಂಡತಿ ಜಿರಾಯಿತಿಯಿಂದ ಜೀವನವೇ ಸುಮಾರು 60 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ಗಂಗಮ್ಮನವರಿಗೆ ಇದೇ ಹಂಸಂದ್ರ ಗ್ರಾಮದಲ್ಲಿ ಆದಿ ಕರ್ನಾಟಕ ತೆಲುಗು ಭಾಷೆ ಲಿಂಗಶೆಟ್ಟಿಪುರದ ನರಸಪ್ಪನ ಮಗ ಸುಮಾರು 65 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ನರಸಪ್ಪನಾದ ನಾನು ಬರೆಸಿಕೊಟ್ಟ ಜಮೀನು ಕ್ರಯಪತ್ರವೇನೆಂದರೆ, ಸೊ ಇಟ್ ಈಸ್ ನರಸಪ್ಪ ಸನ್ ಆಫ್ ಲಿಂಗಶೆಟ್ಟಿಪುರದ ನರಸಪ್ಪ. Whereas, melod, in the mutation, it is shown as Adappa Uruf Narsappa, son of Narsappa. It's totally different, melod. I am not Narsappa, son of, even I am not called as Uruf Narsappa. My father is not called as Uruf Narsappa. He is Adappa, son of Narsappa. There is specific recital in the sale deed. By holding, and there is a inordinate delay in entering the mutation. 31 years delay in making the mutation entries.
Grant was made in favor of Adappa.
Adappa. Produced Annexure melod. It is Chinna Muddappa Namaga Adappa. Whatever the mutation entries as and today, let it be there, melod. And
What was there prior to that mutation entry?
Prior to that, melod, it's Narsappa had his land in survey number 11 to extent of 1 acre to Issa number 11/12. I have produced his mutation also, RTC melod Annexure T in page 23. Survey number 11, Issa 12, Narsappa Lingashetpura.
So since there was an order of status quo passed by this court, this order of the deputy commissioner has not been implemented.
Not been.
Huh?
Not been implemented.
In spite of service of notice on the contesting response number 4 to 6, they have remained unrepresented. Full stop. Next para. Consequently, there shall be stay of the impugned order dated 20/12/2021, passed by the respondent Deputy Commissioner, Chikballapur District, until further orders. Let them complete. Matter has been listed today at the instance of the petitioner who has filed IA number 1 of 2022 for posting. So, however, there is no representation for the petitioner. This matter, release this matter on 18th of August 2022. If there is no representation for the petitioner on the next date of hearing, this writ petition will be dismissed for non-prosecution.
Hearing serial number 44. Yeah, Prasanna. People, Kiran Payar.
ಏನ್ರಿ ಇಬ್ಬಿಬ್ರು ಅಡ್ವೊಕೇಟ್ಗಳು ಓದೇ petition ಅದು ಆ ಮ್ಯಾಟ್ರ್. Yes, yes.
I will file the application next time. I will file the application, required application, because I appear for the first petitioner.
The request of learned counsel for petitioner.
First petition.
Petitioner number 1. A week's time is granted for filing necessary application to bring on record the subsequent purchases.
Right holders.
Huh?
Settlement deed was the settlement right holders.
To bring on record the
right holders, subsequent right holders.
The parties as was directed by this court in RP number
of 2013.
dated. Stop. Release this matter on 18th of August.
If I the petition, I appeared for both the petition. Because the first petitioner is the owner.
ಅಲ್ಲಿ ಯಾರು ಇವಾಗ
The property in my favor.
VR ಪ್ರಸನ್ನ ಇದಾರಲ್ಲ.
Wakalat is not filed. Wakalat ಹಾಕಿಲ್ಲ.
Review petition ಅಲ್ಲಿ ಅವರನ್ನು ಅವರು engage ಮಾಡಿ.
ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಇವ್ರು ಹಾಕ್ತಾರೆ.
ಇಲ್ಲ, ನಾನು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ದೇನೆ, ಆದ್ರೆ ಅದರಲ್ಲಿ ತೋರಿಸ್ಲಿಲ್ಲ.
ಆಯ್ತು, ನೀವು ವಕಾಲತ್ ಹಾಕಿ. ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಪುಟ್ ಅಪ್. Yes. 18.
Raised an objection that delay application need to be filed, shall file my notes. Seeking 2 weeks time.
Delay application
Delay application on the.
for filing the writ petition.
No,
Huh?
For recalling application, recalling of order of dismissal. The writ petition was dismissed as per the preemptory order. As against that, we filed an application seeking to recall the order of
Is
dismissal.
only in the connected matter, is it?
37602 of 2013.
ಅದೇ 37602
ಹೌದು sir.
ಅದ್ರಲ್ಲಿ ಮಾತ್ರ
ಹೌದು.
ಏನಾಗ್ಬೇಕು ಅದ್ರಲ್ಲಿ?
Delay application on ಹಾಕ್ಬೇಕಿತ್ತು along with recalling application. Office has raised an objection that delay application need to be I'll file my
At the request of learned counsel for petitioner in the connected matter, a week's time is granted to file necessary application seeking condonation of delay in filing the application or recalling the order dated 31/1/2022. Respond number? Yeah, next para, in WP number 36190 of 2015, learned counsel for respondent number 4B submits that respondent number 5A, AM Siddhappa, is no more. Stop. The petitioner is required to take steps to bring the legal representatives on record.
But the order which is impugned, section K, page 1999, which has been passed by the
Assistant Director of Land
second
Records.
respondent. On the basis of grant, survey has been conducted. Survey, there were two persons. One is Muniappa, another is Krishnappa. Muniappa has been granted with 1 acre 10 guntas of land in survey number 63. Whereas Krishnappa has been granted 1 acre 20 guntas, 2 blocks, each measuring 1 acre 20 guntas. Survey has been conducted by the authorities. For the survey which has been conducted by the third respondent, both the parties, after receipt of the notice, attended the survey which has been conducted by the Tahsildar, and sketches were prepared. The properties which were granted to Krishnappa and Muniappa were part of survey number 63. Part of survey number 63. Re-survey number has been assigned for the properties of Muniappa as 151. For the property of Krishnappa, 150 and 152 has been assigned. So far as the grievance of the parties with regard to the conducting survey had come to an end. This Muniappa passed away after the survey has been conducted. The widow and children of Muniappa makes an application before the joint director saying that survey has been conducted. While conducting survey, 2 acres 20 guntas was also granted to Muniappa. That has not been identified while conducting the survey. Will Ashima kindly say the 2 acres 20 guntas which according to them which has been granted on 2012-2004. The application has been made by them in the year 2013, endorsing their grievance before the second respondent. When Muniappa was there, he did not raise his voice, saying that I have been granted another 2 acres of land, 2 acre 20 guntas of land. There is some variation with regard to the father's name of Muniappa from the first grant to second grant. Irrespective of it. Will Ashima kindly see the Tahsildar, while conducting the survey in the year 2007, identified the blocks which has been granted to Krishnappa and Muniappa without any hesitation, and both parties have agreed. And his 1 acre 20 guntas has been safeguarded by the authority.
And 2 acres 20 guntas which has been claimed by the widow and children of Munyappa is located at a different place. Is as per the revenue sketch which has been prepared by the authorities. So there is no nexus to the place where it has been identified with regard to the grant which has been made in favor of Krishnappa and Munyappa in the year 1994.
And you also have no dispute. If that land is elsewhere and if that is to be identified and.
Yes, absolutely, we have no objection. Absolutely.
But in the guise of that one.
In the guise of that one, the survey conducted by the Tahsildar has been set aside. That is one aspect of the matter. Absolutely, if he has got any grant elsewhere, let them take it. And I have got the survey sketch, revenue sketch also in my hands. Now the question is, the survey has been conducted in 2007. The appeal has been filed in 2013. There was a delay nearing about 7 years. Even that they did not make any application for condonation of the delay. As per section 51 of the Land Revenue Act, one has to file an appeal within this time limited under the statute, that is within 60 days. And no application has been made. And survey has been set aside by the merely and the appeal which has been filed by the other side. Absolutely, I have no objection in identifying these 2 acre 20 guntas, which is located at a far distance.
Where is that sketch?
Enlarged sketch. That number 2. Enlarged sketch. Annexure F ಅಲ್ಲಿ ಇದೆ, page number 85. ಅದನ್ನ enlarge ಮಾಡಿ ನಮಗೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. Sorry. Annexure F ಅಲ್ಲಿ page 85 ನಲ್ಲಿ ಇದೆ, that we have shown it. That is the 2 acres 20 guntas. Let him take it. We have no grievance against it.
Pinkle mark ಮಾಡ.
Pinkle mark ಮಾಡಿದ್ದೀವಿ.
Where are your properties?
Your Honor, may kindly say, our properties have been.
ಇದ್ರಲ್ಲಿ ಬರೋದೇ ಇಲ್ವಾ?
ಇದ್ರ ಬರೋದೇ ಇಲ್ಲ, ನಮ್ಮದು ಬರುತ್ತೆ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಇವರು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ದಾರೆ. ನನ್ನ ಸ್ಕೆಚ್ may trouble the court to come down to page number 75.
ಇಲ್ಲಿ ಈ ಪಿಂಕ್ ಈ ಪಿಂಕ್ ಮೇಲ್ಗಡೆ ಇದೆಯಲ್ಲ ಇದು ಈ ಭಾಗ ಇದು ನಿಮ್ದು.
ಹೌದು, ನಮ್ದೇ ಬೇರೆ ಅವ್ರದ್ದೇ.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧನೇ ಇಲ್ಲ. ಎಸ್ ಸರ್. Sir, now there is, please understand, then now they have no difficulty. If additional 2 acres of land has been granted to you and that has been identified as this portion, go and get it. During the lifetime of your husband, when he participated in the survey, he did not raise all this objection. ಅಲ್ರಿ, ಅವ್ರು ಬದುಕಿದಾಗ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ದಿರೋ ವಿಚಾರ, ಅವ್ರ ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಈ ತರ 2 ಪೋರ್ಷನ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ದೇ ಇರೋ ವಿಚಾರ, ಅವ್ರ ಸತ್ತ ಆದ್ಮೇಲೆ ನಿಮಗ್ ಗೊತ್ತಾಗಿ ನೀವು ಹೋಗಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ, ಹೌ ಇಸ್ ಇಟ್ ಆಲ್, ಹೌ ಆಲ್ ದಿಸ್ ಇಸ್ ಅದೇ ತೋರಿಸ್ತಾ ಇದಾರಲ್ಲ, ದಟ್ ಇಸ್ ವಾಟ್ ದೇ ಆರ್ ಶೋಯಿಂಗ್. ನಿಮ್ದು ಈ 2 ಎಕರೆ ಈ ಭಾಗದಲ್ಲಿ ಗುರ್ತಿದಾರ ಅವ್ರು ಹೇಳ್ತಾರದು ಗುರ್ತಿದ್ರೆ ತಗೊಂಡೋಗ್ಲಿ ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ, ನಮಗೂ ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಬಿಕಾಸ್ there is a lot of distance between this property and this property. So they have nothing to do with your property.
ಅದು ನಮ್ ಜಾಗದಲ್ಲಿ ಕೋಳಿ ಬರ್ತಾ ಇದೆ. ಪೊಸಿಷನ್ ನಮ್ ಜಾಗಕ್ಕೆ ಬರ್ತಾ ಇದೆ ಪೊಸಿಷನ್.
ಅವಾಗ್ಲೇ ಅವ್ರ ಲೈಫ್ ಟೈಮ್ ಅಲ್ಲೇ ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗೋಗಿದೆ. ಫಸ್ಟ್ ಟೈಮ್ ಯು ಆರ್ ಟ್ರೈಂಗ್ ಟು ರಿಓಪನ್ ದಿ ಕೇಸ್.
ಯಾರ ಪೊಸಿಷನ್ ಇದ್ದಾರೆ ಅದನ್ನು ನೋಡಿ ಅದನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡಿ.
Page number 100.
The contention of the learned counsel for petitioner that during the lifetime of Sri Muniappa, the husband of respondent number 4 and father of response number 5 and 6. When the survey settlement, when the survey was conducted, Hadbast was made in his presence, he did not raise any objection that other than 1 acre and
1 acre
10 guntas of land, another extent of 2 acres, 20 guntas were also granted to Sri Muniappa. Full stop. The survey settlement has taken place way back in the year 2004. 2004 or 2007 na?
2007, 8/7, 2007 and 9/7, 2007. 2 days ಮಾಡಿದೆ. 8/7/2007, 9/7/2007.
So, after a long gap of
7 years from there.
7 years, the widow and children of Sri Muniappa are now raising a contention that 2 acres and 20 guntas were additionally granted in favor of Sri Muniappa, and it is sought to be identified as the land in occupation of the petitioner. Full stop. The petitioner is a subsequent purchaser at the hands of the 7th respondent, Sri Krishnappa. And in terms of the registered instrument, the petitioner is in possession of the lands in question. Full stop. The learned counsel for petitioner has also furnished a copy of the revenue sketch, wherein the 2 acres and 20 guntas of land is identified as a land which is far away from the lands belonging to the petitioner. Full stop. Therefore, learned counsel for the petitioner submits that the petitioner will have no grievance if the land identified in the sketch, which is far away from the lands belonging to the petitioner, is be
any affecting code, in affecting code,
identified, plotted, and the contesting respondents are put in possession of that land. Stop. Next para. Learned AGA is directed learned counsel for the petitioner is requested to furnish a copy of the sketch to the learned AGA. Full stop. learned AGA is requested to secure instructions at the hands of the second respondent, Assistant Director of Land Records, regarding the sketch furnished by the learned counsel for petitioner. Stop.
Is part of writ compilation found at Annexure F, page 85.
In fact, it is submitted that the sketch forms part of the writ petition
Read papers.
in
Page number.
Annexure F.
Yeah, Annexure F, page 85.
Gotaita? If this is correct, if this factum is correct, then there is no dispute between the parties. This matter 2022 to enable the learned AGA to secure instructions from the second respondent. Yes. Interim order granted earlier. Yelli there. Last time extend agirilla. Interim order granted earlier stands extended till the next date of hearing. ಏನ್ರಿ AG ಅವರೇ? There is a registered sale deed dated 25/8/2005, consequent to which the entries have been made, and now they are saying there is no such records available in respect of Akar Bandhu, LR Tipti, and endorsement as such is given. So I directed you to secure instructions. ಕೇಳಿಲ್ವಾ ನೀವು? Matters called out. There is no representation for the petition. So, nevertheless, at the request of the learned AGA, release this matter on 18th of August to enable the learned AGA to secure instructions from the respondent Tahsildar. Yes.
Hearing for petition. Respond number 2.
Learned counsel for the contesting respondents submits that the statement of objections are ready. They will be filed in the office. So a copy is out to the learned counsel for petitioner.
Next week and a date.
Interim order ಇದೆಯಾ ಇದರಲ್ಲಿ?
ಹೌದು ಇದೆ ಸರ್.
ಮತ್ತೆ ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ 20 ವರ್ಷದಿಂದ ನಾನು
ಸರಿ ಆಯ್ತು, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ನಿಮ್ ಫೇವರ್ಲಿ.
ಇಂಟ್ರಿ ಮಾಡಿದ್ರು ಸೇಲ್ ಮಾಡಕ್ ಬರಲ್ಲ, ನಾನು ಮುಖ್ಯ ಆಗ್ತಾ ಇದ್ದೀನಿ, ಆದ್ರೆ ಅವ್ರ ಇಂಟರ್ಫಿಯರ್ ಆಗಕ್ ಬಿಡ್ತಿಲ್ಲ.
ಏನ್ ಮಾಡೋದು? 2020 ಮ್ಯಾಟರ್ ಇದು. There are very old matters here. Yes. Interim order granted earlier stands extended to the next date of hearing.
Week after next also.
Yes.
Number 50, my lord.
49.
49.
Counsel. A submission is made on behalf of learned counsel. Sri Mohan Kumar T. ಅದೇ ಮೋಹನ್ ಕುಮಾರ್ ಟಿ ತಾನೆ ನಿಮ್ಮ ಹೆಸರು? ಕಿರಣ್ ಎಸ್. ಕಿರಣ್ ಎಸ್. ಏನ್ ನಿಮ್ಮ ಹೆಸರು? ತೋರಿಸಿಲ್ವಲ್ಲ ಇಲ್ಲಿ. ರೋಹನ್ ಹೊಸಮಠ್ ಹೆಸರೇ ಇಲ್ವಲ್ಲಪ್ಪ. You don't have the cause list with you? ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರೆ ವಕಾಲತ್? That the learned counsel for respondent number 4 has tested positive for COVID-19. Matter after 2 weeks. Interim order granted earlier stands extended to next date of hearing.
Serial number 50, I appear for respondent number 5.
Yes.
Challenge annexure A. Annexure A and B.
I have to file my statement of objections, my lord. Only last
Yes,
week I filed wakalat, my lord.
Court of RJ. Report. ಬರೀ ಮೆಮೊ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. ಏನ್ ರಿಪೋರ್ಟ್ ಇದೆ?
Lord, I appear for respondent number 5, my lord. Kindly,
Yes.
only 2 weeks I have filed wakalat, my lord, to seek instructions, my lord. I'll have to file my statement of objections.
What is the matter about?
In this case, my lord, the propositors of Sidlingapur, they had 5 sons. After partition, my lord, there was a totally 8 guntas. 6.5 guntas was allotted to Nanjappa, petitioner father.
One ನಿಮಿಷ. Who approached the assistant commissioner?
Assistant commissioner is the respondent 5 or 6.
Where is the order?
Kindly
Annexure F.
Annexure
F.
Annexure F.
Annexure F.
B.
Annexure F, page 25.
17.
Page 17.
17.
Order.
17. The crux of the point.
B. Rajappa, Shiv Basappa. They approached the assistant commissioner. That is the respondents.
That is the response.
One submission, Milans. I am Shiv Basappa. I don't know how my name came into being in this. I have not approached and I have not been served with the notice also.
All right. Let us. Mr. Anil Kumar, you are appearing for this B. Rajappa, is it?
Please, my lord, 5th respondent, my lord.
B. Rajappa.
B. Rajappa.
Please,
Please, madam.
And he is saying on behalf of
Voice not able to hear, my lord. Not audible, my lord. Not audible, my lord. Not audible, my lord.
ಈ ಕೇಳಿಸುತ್ತಾ?
Please, my lord.
ಹೇಳಿ. You approached the assistant commissioner.
Please, my lord.
Year 2012, 2013.
10 years.
Seeking a challenging MR number 36 of 1963-64.
Okay.
How is it permissible, sir?
Lord, I only filed wakalat. I'll seek instructions and make my submission, my lord.
ಏನಿಲ್ಲ ಇದರಲ್ಲಿ.
At least I'll make my submissions, my lord. Then your lordship can dispose of.
ಬರ್ಕೊಳ್ಳಿ.
Kindly be taken up on 23rd, my lord.
The main contention of the petitioner is that the contesting respondent number
5, my lord.
Number 5, Shri B. Rajappa, challenge mutation effected in the name of the petitioner in MR number 36 for 1963-64.
Petitioner father.
Petitioner's father. 64. ಇನ್ನೊಂದಿರ್ಬೇಕಲ್ಲ MR ನಂಬರ್. ನಿಮ್ಮ ಹೆಸರಾಗಿದ್ದು?
Pitraj 27/11/2002 ನಲ್ಲಿ.
MR ನಂಬರ್
28 artisanal annexure give.
ಹೇಳಿ MR ನಂಬರ್ ಹೇಳಿ.
MR number 28 of 2002 and
8/2023, my lord.
ಬರ್ಕೊಂಡಮ್ಮ. In the year 2012, so moreover, the entries in the revenue records were a registered sale deed dated 11/4/1966 in respect of 1.5 guntas of land. So, next para. Over at the request of learned counsel for respondent number 5, released this matter on 18th of August 2022.
22nd, my lord. 22nd, my lord.
Bada 18th banre. And there is nothing in this.
Please, my lord, I'll not be in station. 22nd, Monday, it may be.
22nd.
Please, my lord.
23rd.
23rd.
Interim order may be extended.
Interim order granted earlier stands extended in the next date of hearing. Yes. Should AG over secure instruction from the 4th respondent, additional principal chief conservator of forest, as regards communication dated 13/12/2021 at annexure H. ಏನಮ್ಮ? ಒಂದ್ಸರಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ. ಇವನ್ ನೋಟ್ ಮಾಡ್ಕೊಂತ ಇಲ್ಲ ಅಂತ ಕಾಣ್ತದೆ. As a last opportunity, at the request of learned AGA, release this matter on 18th of August.
I have received instructions.
ಎಲ್ಲಿದೆ?
Filed a memo that though we have allotted to them as under the forest people are raising an objection and the DC office in the information. We're saying that it is a forest area.
Allah, that is why we are directed you to secure instructions from the forest officials, principal chief conservator of forest. As regards communication dated 14/12/2021.
Yes. DC officer have sent a letter.
ಅವರೇ ಕಳ್ಸಿರೋದು ಅದು.
Forest owner DC officer.
ನಮಗೆ ಬೇಕಾಗಿರೋದು ಅವ್ರದಮ್ಮ.
Lords, may kindly take this up on 19th.
ಆಯ್ತು. 19th
Last
of August. Yes. Huh? ರಜಾ ಇದೆಯಾ? 22nd.
Some other places, not regarding same survey number, same project, same project, alternate land. Other people, but not to this proceeding is only in respect of other land.
Not. He is contending that the land identified for him is now in unauthorized occupation of this other person. But here it is not permissible. Even if he has challenged that one, it is not permissible to grant that land. That see, an application under form number 53 can be granted only if there is no objection from any other quarters. If this land has been identified for displaced persons, it cannot be granted to that other person for regularization of unauthorized occupation. ಅವ್ರಿಗೆ ಬೇಕಾದ್ರೆ ನೀವು ಬೇರೆ ಜಾಗ ಕೊಟ್ಕೊಳ್ಳಿ. ಇವಾಗ ಏನಂತ ಡೈರೆಕ್ಟ್ ಮಾಡಿದೆ ನಾನು?
They have told if they find any alternate land that is available in survey number 56, they try to accommodate but I file an application only in respect of the copy on them both petition and
yes.
They will try to find out an alternate land either in 57 or
ಆಯ್ತು ಮಾಡಿ.
Only thing why it is not granted now to grant that
Allah, see, but the fact is that he is a displaced person. So therefore, you had to grant it.
All these places was falling into market. 85 it came to Bangalore. There are already been a time there are people who are and some of them have filed the application and they got order from regularize market. These two people use the application rejected, but we will try to find out if there is any alternate that can be granted.
Right.
It's only because we don't have that grant order. I will the application to recall.
Right.
Sorry, my lord.
All right. Yes. ಯಾವ್ದು ನಿಮ್ದು? Matters called out. There is no representation for the petitioners. Release this matter on 18th of August.
Yes. Petitioner husband was granted the land. 1972. As per annexure A, my lord, endorsement issued by the Procedural.
ಏನಂತ
Records are not available in the office. Grant records, personal records are not available in the office. But the grant was made in favor of the petitioner husband was confirmed. You will also kindly see the endorsement issue. Page number 15, man. Type it down. ಸಕ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ಆರ್ ವೆಂಕಟೇಶನ್ ರಾಮಣ್ಣ ಆದ ನೀವು ಉಲ್ಲೇಖಿಸಿದ ನಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಕೀಳುಕೋಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 48ರಲ್ಲಿ 4 ಮತ್ತೆ ಮಂಜೂರಾಗಿರುವ ದರಖಾಸ್ತು ರಿಜಿಸ್ಟರ್ ದಾಖಲೆ ಇತ್ತು. MR 1/7374 ಅಂತೆ ನಿಮ್ಮ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿದ್ದು. ನಿಮ್ಮ ಹೆಸರಿಗೆ 1974-75ರಲ್ಲಿ 2000-2001 ವಾಣಿ ಇತ್ತು. ಆರ್ಟಿಸಿ ಸರಿ ಅಷ್ಟೇ ಬದಲಿ ವಿಚಾರವಾಗಿ ನಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ನೀಡಿರುವ ದಾಖಲೆಗಳಂತೆ ಉಲ್ಲೇಖ 1ರ ವರದಿಯಂತೆ ಅಭಿಲೇಖನಾಲಯದಲ್ಲಿ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತನ ಇಲ್ಲದ ಕಾರಣ ನೈಜತೆ ಕೋರುವ ವರದಿ ಸಲ್ಲಿಸುವುದರಿಂದ ವರದಿಯನ್ನು ವಿಲೆ ಇಟ್ಟಿದೆ. ಅಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ನಾಟ್ ಅವೈಲೇಬಲ್ ಇನ್ ದಿ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್. But they themselves admitted that the grant was confirmed.
How can they admit?
On the basis of
ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್?
grant orders.
ಅಲ್ಲಿ ವೆರಿಫೈ ಮಾಡೋದಕ್ಕೆ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಹೌ ಕ್ಯಾನ್ ಈ ಕನ್ಫರ್ಮ್ ದಟ್ ಯೆಸ್ ಇಟ್ ಈಸ್ ಗ್ರಾಂಟೆಡ್?
We are producing all the entire documents.
Correct, sir. That has to be verified from the original records, like the grant register, Sagold issue register, and other contemporaneous records. When they are saying after verifying from the original records, it is found that there is no such information available, then what to do?
Up-to-date documents are gathering from the office itself, my lord. But they have given endorsement only that the records are not traced now itself. You will also kindly see the grant order and mutation register. Mutation order are also produced. Client has get all the original documents, including the RTC up to date. Mutation order was also there, H was also there in our participant.
ಇದ್ರದ್ದು ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ ನಾವು
In the earlier application, you will not
ಏನೋ ಮಿಸ್ಸಿಂಗ್ ರೆಕಾರ್ಡ್ಸ್.
and also this honorable court.
Get that,
Honorable court clear occasions past the order and remanded matters to be responded.
ಏನಂತ ರೀಕಂಡಕ್ಟ್ ಅಂದ್ರೆ we get that other order that I had passed. If there are missing records, there is a separate committee constituted. It has to be placed before that committee. Learned area is requested to place on record a recent decision passed by this court in respect of the committee constituted by the state government for going into the missing records cases. Released this matter on 18th of August.
Therefore, the petitioner, this is second round of litigation. The petitioner's father, Sinappa Pujari, was a tenant, my lord. He made an application, and after his death, his wife made an application under form number 7 to grant occupancy rights. Annexed A is the application, my lord. The tribunal, considering the application, granted occupancy rights in favor of the petitioner's mother on 23/7/1981. Annexed B, my lord. Since all the lands made in the application were not granted, a modification application has been filed. On the basis of the modification application, a modified order has been passed with regard to extent on the method on 2/12/1998, Annexed C. After lapse of 30 years, my lord, the third respondent hearing preferred a writ petition Annexed E in WP 35794 of 2013. In that, my lord, I request my lords to kindly come to page 64, para 8 of the said petition. Said petition, this honorable court confirmed the grant made in Annexed B on 23/7/1981 and remanded only to the extent of modification order. Matra remand ಮಾಡಿದ್ದು. I may permitted to read para 8 below. As far as order dated 23/7/1981 is concerned, on the reading of the same, it is noted that the father of the petitioner was arraigned as respondent in the said proceeding, appeared before the land tribunal, and in fact he has expressed his consent for grant of occupancy rights in respect of Tiruvallveli village is concerned. Therefore, this is not a case where the order has been made behind the back of the petitioner's father and in violation of principles of natural justice. As far as Bondantila village is concerned, the tribunal considered the case of Srimati Girija, who had filed form number 7 on merits and granted certain extents of land in survey number as extracted above. The said order was not assigned by petitioner's father during his lifetime. Petitioner has also not assigned the said order for almost 33 years. Therefore, any challenge made to that order at this point of time cannot be entertained, as this writ petition is made by the principles of delay and laches. This honorable court confirmed the order of 23/7/1981 method. In para, page 74, para 10. The aforesaid decision was squarely applicable to the instant case, having regard to the facts of the present case. Therefore, the challenge made to the order dated 23/7/1981 is rejected on the ground of delay and laches. Insofar as challenge made to the order dated 22/12/1998 is concerned, on perusal of the said order, two things become apparent. Firstly, the said order has been made against the petitioner's father, who had died in the year 1987. Therefore, the order made against the dead person is a nullity. Secondly, once by order dated 23/7/1981, the land tribunal had granted occupancy rights in respect of certain survey numbers and certain extents of Tiruvallveli and Bondantila village. The land tribunal become functus officio insofar as the said proceeding is concerned. Thus, it did not have power or jurisdiction to modify or alter order dated 2/12/1998. In this regard, reliance could be placed on section 48A of the Act, which states that the order of the land tribunal under section 48 shall be final, and tribunal shall send a copy of every order passed by to the Tahsildar and the parties concerned. Proviso further states that the tribunal may, on the application of any of the parties for reason to be recorded in writing, correct any clerical or arithmetical mistakes in any order passed by it. Further, proviso states that the tribunal may, on its own or on the application of any of parties for reasons to be recorded in writing, correct the extent of land in any order passed by it, after causing actual measurement and after giving an opportunity of being heard to the concerned parties. As a counter to this, the learned counsel for respondent 327 submits that there was a typographical error in order dated 23/7/1981, in which land tribunal did not grant occupancy rights as sought for by Srimati Girija. Therefore, it is not a case for additional survey numbers and additional extents of land were sought. What was sought for is only correction of typographical error in the order dated 23/7/1981, which is consonance with form 7 filed by Girija. Be that as it may be, fact remains that the modification made by the learned tribunal is in the name of dead person, without issuing notice to the legal representatives of the Gilbert, Philip Piris, but
were died in the year 1987.
So it was remanded.
Remanded only in respect of modified
Right.
order. The third respondent preferred the writ appeal. The writ appeal, while arrested, the order of the celebrated single judge has been confirmed. Page 81 maybe. I may be permitted to read page 18. The appellant is aggrieved by the order dated 1/8/2018 passed by the learned single judge in writ petition. It is contended that the remand of the matter to the land tribunal is a futile exercise in as much as the material would indicate that some of the lands are Punja lands in respect of which no tenancy claim could be made. The land tribunal do not even have jurisdiction to entertain it. However, we have the view that the nature of the land is not subject matter of the dispute presently. The reason assigned by the learned single judge is that modification made by the land tribunal is in the name of dead person without issuing notice to the concerned legal representative. Therefore, for that limited purpose, the matter has remanded to the tribunal for consideration. My lord, now the tribunal has gone beyond its jurisdiction and cancelled a grant which was made in the year 23/9/1981. That has been challenged before my lords. At least, my lord, the tribunal would ought to have considered and confirmed the order of 20, because this honorable court has confirmed the order dated 23/7/1981. It would have rejected the amendment. ಮಾಡಿದ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಬಹುದಿತ್ತು. ಅದು ಬಿಟ್ಬಿಟ್ಟು 23/7/1981 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಂತ ಲ್ಯಾಂಡ್ಸ್ ಕೂಡ it has been rejected. Few lands of Gondantila Village has been taken back, stating that the said lands as Punja lands. That has been done.
What about the additional lands that you were talking about?
Without in the said application, without all the lands which was sought were not granted in 23/7/1981. Hence,
Correct. Adr ಬಗ್ಗೆ ಏನು ಮಾಡಿದ್ದಾರೆ?
ಅದನ್ನು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಿದ್ದಾರೆ. He has not considered.
That is also rejected.
That is also.
And some of the lands that
some of the lands which has been granted in 23/7/1981 is also rejected. The order is set, my lord.
So what is your contention now? Are you restricting your argument only in respect of?
Yes, my lord. I restrict, my lord, the 23/7/1981. If this court confirms, I will restrict my claim, and I am happy with the order lands which is granted as per.
Yes, sir.
Lords, as far as the agricultural lands are concerned, lords of.
Sir, one thing is very clear
Yes, lords.
from the order earlier passed by this court. The order passed in the year 1981 cannot be reopened. It was made very clear.
My lords,
So therefore, the learned council has now submitted that what was confirmed in 1981, if that to that extent it is confirmed, it's enough. I do not want any further.
There's a two-court
That
submission.
cannot be reopened.
May I make a two-court submission?
Yes.
Lords? The subject matter of my lords, the grant, my lords, are the grant of the occupancy rights of my lords are dry lands. That is my lords.
Sir, Baradilla, sir, please don't try to reopen what was granted in the year 1981. The subsequent application made by them seeking modification, to that extent he concedes that I will withdraw that
My lords,
claim.
my lords,
The tribunal.
The grant itself, my lords, of 1981, my lords included Punja lands. Punja lands.
Then we can't go into that. We can't go into that aspect, sir.
My lords, that cannot be considered. The reason is this, my lords, this honorable court, my lords, and the honorable Supreme Court.
Sir, where is the challenge raised to that?
My lords, your lordship, may kindly see page 81 of the honorable division bench order. My London friend did not read that operative portion of that order. My lords, may kindly see page 81, the second part of the order, my lords. We are of the view that the reasoning assigned by the London single judge being just and proper, no interference is called for.
Yes.
Next, my lords, the question with regard to the nature of land is necessary.
Is
for
not
determination
necessary.
Of this stage.
Is not.
Necessarily, my lords, pausing here for a moment, necessarily the tribunal would take into account the contentions with regard to the jurisdiction to decide the lands or otherwise. The petition is being devoid of merits is dismissed. All the contentions are
No, sir.
left over.
No. That cannot be read saying, see, if the division bench was of the opinion that the directions given by the learned single judge restricting the matter remitted back to the land tribunal to consider the second application made or the application sought for modification need not be restricted only to the modified order. It can go even to the order, original order passed in the year 1981. there is no such a discussion made by the division bench, and this cannot be interpreted in such a way that the division bench gave permission to the land tribunal to go to reconsider that order also. That is not
submission, my lords. The honorable division bench, my lords, in its wisdom, my lords, it makes a categorical observation.
No, sir.
Necessarily, the tribunal will take into the contention.
Sir,
The reason is this, my lords,
No,
before the learned division bench, 2 judgments were cited by me. My lords, that is, my lords, of the Karnataka High Court and
There is no discussion.
my lords, the
There is no
my lords,
discussion by the
my lords,
division bench, and it has not set aside that part of the order of the learned single judge.
But my lords, my lords, by virtue of a prerogative, my lords, the division bench's order, my lords, are given a direction to the land tribunal saying that the nature of land should be considered and all contentions left open. That means, my lords, the issue of, my lords, the dry land, the
No,
Punja
sir.
land, may I make a submission?
No,
The dry land or the Punja land, which cannot be a subject matter of the land under the Land Reforms Act. itself.
Maybe, even if you want to put it that way, it is still to be restricted only to the modification application.
My lords,
It cannot extend to the earlier order passed in
at
1981.
this stage, my lords, may I make a reasonable submission? As far as the wetlands are concerned, my lords, of Tiruvali village, the landlord of.
Anyway,
May
The
I make a
learned council has considered
Yes, my
that
lords.
even if it
That
is in
extent,
respect,
my lords, let the order of the tribunal be confirmed, my lords. But as far as the dry lands are concerned, my lords, at the final disposal of by this honorable court, may it be kindly considered.
about what?
My lords, about the dry lands of the schedule B, the imputed ordinance schedule B.
Not dry land, sir. He is saying, I don't press on that application itself. That is the end of the matter.
To end the litigation, my lord, lands which has been
My
granted.
lords, as in the first order of 1981, even the dry lands, my lords, which
That
cannot be.
cannot be
subject matter-
reopened, sir. At any cost, that cannot be reopened.
My lords, there is a
No,
specific direction by.
You have not challenged it, sir. It is on a subsequent application made by this person seeking modification of that order. This order has been passed. Where is the question of reopening that?
My lords, even that application, my lords, the tribunal has held, my lords, the application under section 45A6 cannot be, my lords, for the purpose of amendment. The learned civil judge, my lords, his lordship, Justice Nagaratra, as then she was, my lords, makes a finding, my lords, that once when an order is passed by the tribunal, it becomes functions of issue. The order of the land tribunal cannot be tinkered by them. When such an observation is there, my lords, how can, my lords, the land tribunal consider such an application, my lords, and it's rightly rejected.
Which application?
My lords, the application under section 48A6, my lords, which was filed by the tribunal, which was considered, that has been rejected. That includes, my lords, several additional wetlands and dry lands.
That is why, sir, he is saying the subsequent application seeking modification,
My lords,
by virtue of which the land tribunal passed the order. He says, I don't press that application.
My lords, even otherwise, my lords, if it does not press that application, my lords, for modification of the year 1998, then, my lords, even the 1981 grant, to the extent of, my lords, my dry lands
No,
which
sir.
I'm in possession.
No, sir.
May-
You have not questioned that order.
My lords,
You have not
my-
questioned
my
that
lords,
order.
my
It-
lords,
That cannot be
It's
reopened.
not an order in camouflage, my lords. There's this particular, my lord, direction. My lords, may I read it, my lords, the relevant para.
Sir, we need not go into that at all. Because there was a clear direction given by the learned single judge stating that in terms of section 48A, the tribunal becomes functus officio
Yes,
the
my lords.
moment it passes the order.
Yes, my
So
lords.
therefore, to that extent, that is why it was clearly stated that what was directed in the year 1981 has attained finality, that cannot be reopened. In respect to the subsequent application made in respect of other properties,
My lords, other.
only to that extent, the matter was remanded for reconsideration.
My lords,
So therefore, at any rate, the original order passed by the land tribunal in the year 1981 cannot be reopened.
My lords, that, my lords, includes, my lords, that it.
Barodilla, sir.
What the tribunal. has-
Even in respect of the nature of the land that you are talking about, with
Dry lands, my
reference to,
lords, Punja lands, my
with
lords.
reference to one sentence of the division
My
bench.
lords, not the dry lands are considered. I filed documents to show.
That is
These are
the-
all, my lords, subject matter of acquiring lands.
Correct, sir.
Stones. How
That
can this
is-
be agricultural operation, my lords?
that is-
Yes,
excluded from the purview of the act.
That is regarding
That is the
the
direction,
second.
my lord, given by the London Division Bench to consider that aspect. How can, my lords, an illegal order be, my lords, justifiable, my lords, when they.
Sir, have you challenged that order, sir? Have you challenged that order of 1981?
1981, I have not, my lords.
Then
The only law, the question which I raised before the division bench, my lords, was regarding the dry lands. The division bench, my lords, in its wisdom said, with regard to, my lords, the dry land, it's necessary the tribunal to take into account the contentions regarding the jurisdiction to decide otherwise.
correct.
It kept the land.
That is restricted to
all
the
contentions left open.
second application made and the lands which are sought to be included subsequently. To that extent, even the nature of the land was required to be considered.
My lords,
Now he is giving up the entire application.
application, they are not doing the landlord a favor, my lords. They are getting, my lords, 1.221 acres of wetlands. They are getting 9 acres of dry lands out of 15 acres.
No, sir.
My lords, all the dry lands have in possession.
No, sir. You can't reopen the order dated 1981 at any cost.
My lords, as far as dry lands are concerned, my lords, my respectful submission, my lords.
Wetlands or dry lands or whatever, that is to be restricted only to the second application made by the petitioner hearing. And he is giving up the entire thing, whether it is dry land or wetland or whatever.
The question of giving up, my lords, doesn't enrich the landlords. It doesn't benefit at all.
End of the litigation.
Sir, you have not raised a challenge to that order, sir.
My lords, my humble and limited submission before this
Yes.
honorable court, the division bench, my lords, I said all contentions left open with regarding
All
the dry lands are concerned.
All right, I will consider this. I'll pass orders tomorrow.
Obligations.
Release this matter tomorrow. For dictation of order, yes. Preliminary hearing ಆದ ತಕ್ಷಣ ಆಗ್ತದೆ. Yes.